Department of Justice.
This workshop on the practice of arbitration and mediation and its emerging trends serves as a dynamic platform to equip legal professionals, academicians, and students with contemporary dispute resolution skills. Such programs elevate the standard of legal education, fostering a culture of innovation, efficiency, and excellence within the justice delivery system.
It is indeed a great honor to have such esteemed guests and legal experts with us today. We are confident that the session will be enriching and insightful for everyone present. To begin the insightful journey, we now invite Advocate Prakhardeep. Mr. Parker is a principal associate at Shradul Amarchand Mangaldas. He brings over 10 years of expertise in construction arbitration and high stakes commercial disputes with a focus on large infrastructure projects across railway, tunnels, hydro, and oil and gas. Mr. Parker has successfully handled matters exceeding INR 10,000 crores. His notable wins span industries like telecom, energy, and pharmaceuticals, making him a trusted name in India's arbitration landscape. Sir, kindly join us.
Good morning, everyone. So can we begin the presentation for today?
Sure, sir.
First of all, very good morning to all of you. I'm very thankful to the university for inviting me today, and especially Dr. Professor Shobita Srivastav for extending the invitation to me for presenting today on a topic which, as law students, as young lawyers, and as someone who wants to really get into the field of arbitration, is something which is the very most fundamental aspect of the arbitration practice, which is pleadings and evidence in the arbitration. Now, before I begin, I understand that most of you are law students and maybe young practitioners who are venturing into the field of arbitration or aspire to be in the field of arbitration. So I'll just begin by giving a broad overview of what is arbitration and why it is different and how is it different from the normal litigation course. Now, arbitration is just an alternative dispute resolution mechanism. Of course, when there is a dispute between the parties, then you invoke arbitration and you can go to courts. But if the contractual understanding between the parties is that instead of going to the regular courts, filing a suit, filing a claim, and contesting there, parties can always agree for an alternative mode of resolution, which is arbitration in this case. Now, what is an arbitration? Arbitration is just like a court, which is, you can say, a private court setup, where you choose the way you want to resolve your dispute. If I and suppose A and B have a dispute arising out of their contract, say for supply of goods, and A and B have agreed that in case of any dispute over pricing, supply, or any breach of the contract, we will resolve this dispute through arbitration. Then A and B have now determined a pre agreed procedure by which they do not want to go to courts, but they want to go for an arbitration. Now, what is an arbitration? Both of them can agree on the procedure, which is uh, who will be the arbitrator, where will be the arbitration conducted, like what will be the seat of arbitration. For instance, if the goods are being supplied from Delhi to Jaipur and there is a dispute, so parties can choose that if there is an arbitration, where this arbitration will be held. Will it be held in Jaipur? Will it be held in Delhi? Or will it be held at a neutral place? Parties can even decide who will be the arbitrator, and in cases there can be a sole arbitrator or a three-member tribunal where each party will nominate their own arbitrator, and the presiding one would be nominated by the rest of the two nominee arbitrators, or as per the mechanism. So arbitration essentially is a very customized process where you can decide and choose everything. And in order to implement that understanding between the parties, you have the Arbitration and Conciliation Act of 1996, which has the procedure of how an arbitrator is to be appointed, how a case is to be filed, how evidence is to be done, how an award is to be passed, how an arbitral proceeding is to be conducted, and how do you then challenge that award and other proceedings which emanate out of the arbitration act. So that is what is the purpose of an arbitration. The aim was always to lower down the burden of the judiciary to have disputes resolved, which are commercial disputes between the parties, where the dispute is only related to money and the private rights between the parties, which is the commercial agreements, to have a forum where you can resolve your dispute as at your own cost. So in arbitration, you pay the fees to the arbitrator, basically what you're paying in the court fees to in court. In arbitration, you pay the arbitration fees to the arbitrator. And basically, you tell this person that you now resolve my dispute. Now, that is what the whole arbitration process is. It's a private court. But what happens in a private court? How do you resolve? How do you file your case? Is the topic for today's discussion. Now, if as a student of law, you must have studied the CPC, you must have studied what plaint is, what reply is, what application is, what written statement is. Arbitration is the same. It is just there is a change in the terminology of how you file a case. You institute a suit. Here you file a statement of claim. In the court, you file a written statement. Here you file a statement of defense. In court, you file something which is called as a replication. Here you file a rejoinder. And there is a counterclaim as well, which is similar to what you have in the court litigation system. So essentially, the pleadings, the fundamental pleadings remain the same. It's just a change in the terminology and arbitration procedure when it comes to evidence. Arbitration is not bound by the principles of CPC and the principles of Evidence Act. It is more of a less formal procedure where parties can even decide the rules of evidence and the rules applicable to the pleadings and how it is to be conducted. So it's a more uh, direct process, less formal, more inclusive in nature, that it is more participating in nature where parties can agree on a lot of things and how it is to be done. But whatever it is, ultimately it is a proceeding where both parties are contesting. One party has a claim, one party has to defend that claim, the other party may have its own counterclaim. So you basically have to follow the general principles of how a pleading is to be made. Pleading as in how your case has to be filed. So uh, today's session is on the practical aspects of how do you prepare a case, because most of you will, if you even if you are not, going to be an active arbitration lawyer, even if you are going to be a disputes lawyer, a litigation lawyer, you really need to understand how to build a case, because that is something which you may learn in theory, you may read in CPC, but until and unless you have a practical experience of developing a case, you will not really understand how do you build a case, how do you really draft your first pleading, which is of the statement of claim. Or if a statement of claim is given to you, how do you draft reply to that statement of claim by way of the statement of defense, or in terms of CPC, how do you know, draft a plaint and how do you reply to a plaint in terms of written statement. So today's session is all about the practical aspects of how do you draft the pleadings. I'll be sharing my screen just to give an overview of what kind of pleadings are in the arbitration. So just give me a moment. Can someone allow me to share screen, because I'm not really getting that option from my, because I've logged in from two users. So can just someone allow the screen
Yes, sir.
shares?
Just a
Yeah,
moment, please.
yeah, thanks.
Sir, kindly try sharing your screen now.
I am trying, but there is no option given to me.
Oh, okay, sir. I'll check. Just a moment, please.
So no, I am not logged in from the ID which I'm speaking right now. There's just from the same name you will find another user ID, Prakhar, because I'm using my laptop for screen share.
Sure, sir. I'll look into it.
I've just said hi, so you can allow.
Yes, sir.
Yes. So that user has to be allowed for the screen share. Anyway, I'll just try. Uh, yes, I can now share it. Can you guys see the screen now?
Yes, sir. It is visible.
So on today's topic, we are going to study what is a statement of claim, counterclaim, defense, and strategy for witness. Now, as I told you that, you know, in arbitration, the pleadings are to be known as statement of claim, statement of defense, and the counterclaim. And then what we will also do is we'll try to get an overview what witnesses, how in evidence is led in arbitrations. So let's straight away come to what a statement of claim is. Under the Arbitration Act, the pleadings are defined under Section 23 of the Arbitration Act. So the parties under 23 says that a party who has a claim will file a statement of claim, and the reply would be in the form of a statement of defense. Okay. Now, what exactly is a statement of claim is a question which a lot of you may have, that what is it? Now, what is a statement of claim? Today, if I have to present a case and I have to give a statement, like, this is my case. So, a statement of claim, as a literal meaning, is that it's just a giving a description of what your case is as a party, because you are presenting it before a court or a tribunal in this case. So, statement of claim, you once you start drafting it or once you draft in future, you need to take these things in mind. At first, you will give the entire description of the party, that who are you as a claimant? I am X, I am Y, I am this, I am a company, I am a entity, and these are my party addresses. I am represented by this X person. And then you start with the facts. Now, in arbitration dispute, the essential part is that it's always arising out of a breach of a contractual understanding between the parties, because ultimately in arbitration the claim arises out of a breach of contract. If A and B has, as an example I was giving you, that supply for goods. So if the goods are not supplied within the time period, there will be a breach of contract, and the breach will have consequences, and therefore you will file a case. And similarly, if you have supplied the goods and you have not been paid for the money, then you will have a case. So you need to write all the facts that, okay, A and B entered into an agreement. The terms of agreement was this. The the agreement, as per this agreement, this had to be done as per this provision. I did this. I performed my obligations of the contract. The reciprocal obligations or the other side's obligation were this, the other side breached the contract. As a consequence of this breach, I have this claim. So that is what you write, the facts of the case. Then you, of course, write the relevant clauses of the agreement. That because ultimately in arbitration, the cause of action arises from the agreement itself. So you need to write what provisions of contract you are relying on. Where is the arbitration provision? How is that tribunal having jurisdiction to entertain that arbitration claim? Then you write the dispute in question, that ultimately there is a dispute, the facts lead to a dispute, what are the points, and finally, what are the reliefs which are being sought. So, what are the claims? Just to give an example for a supply of goods contract. If, as a seller, you have supplied the goods and you have not been paid, what will be your claim? Your claim can be payment for balance, your invoice or purchase orders, along with the interest. If you have suffered further loss because of non-payment, then you will add your claim. Similarly, as a buyer, if you are recipient of goods, if you don't receive goods in time, what is your loss? Does your contract have a damages clause where you can claim some liquidated damages? Does your contract have a risk and cost clause where if the goods are not supplied to you by, say, today, Friday, you have availed purchased goods from third party, you will claim that difference in price. So essentially, statement of claim is all about understanding what the contract is and what is the breach which emanates out of the contract and what is the relief which is being sought. Now, a lot of students and a lot of uh, lawyers confuse this statement of claim and try to, think that arbitration is all about Arbitration Act. But uh, that's a misconception that many people have. Arbitration is everything but the Arbitration Act, because it is Arbitration Act can only give you a procedure how to file a claim. But what is the content of that claim? How do you need to structure it is not written in the Arbitration Act. It is written in the contract between the parties. And if the law which you need to really understand how to draft all these statement of claim is the Indian Contract Act, because the breach of a contract arises out of the Indian Contract Act. There is a breach of section, say, 55 of the Contract Act, reciprocal obligations. Then the damages arise out of section 73 or 74 of the Contract Act. So your understanding of the Contract Act is fundamental before you draft any pleading or any statement of claim or statement of default, because that's how you will understand what law will apply. Because in arbitration, the only law which applies is the Contract Act. So that's where the whole interpretation lies of which contract provision, how to do it, whether it's a breach or not, whether the breach is material or not, right? So, and also the last point is that you have to follow the language of the arbitration. Of course, if it is in English, then you do it in English. In international commercial arbitration, sometimes the language official is, say, French. So you may have to get the translated and, have to file it accordingly. And most importantly, the essentials of SOC, if you can just see the underlying part, is the documents which you want to rely. So even if you have a very strong case, but you don't really rely on any document supporting your claim, then your statement of claim would be worthless, because later on the tribunal will say that it is without any evidence. So if you have a breach of contract, suppose it's a claim for payment of invoice, payment of your bills. If you don't file the bills along with your statement of claim that these are the bills which are not paid, then your claim is not sufficient, because just merely writing that I have a claim of say 1 crore or 2 crores of certain invoices by giving the description of those invoices is not enough. You need to say which are the invoices, identify those invoices, annex it along with your statement of claim because that proves your case. Pleading is only the narration. As I told you, it's just a statement of claim. The documents or the evidence are the main thing which you have to file along with your claim. Now, let's see a bit of a checklist how a statement of claim has to be filed. So, you need to, first of all, whenever you are preparing a statement of claim, as I told you, you need to have a chapterization that what your thought process is. Uh, it will include parties, your case, breach of contract, relief sought, and other aspects. Then you have to really select the documents that which are the most important documents you want to rely on. So if you have a case for claim for pending invoices payment, then you need to invoice, then you need to attach the payments. Then also, sometimes there are interstate communication between the parties, which leads to breach. Mostly in common commercial world, there are a lot of exchange which takes place by way of an email. Uh, those emails you need to really see what are the relevant ones which you need to file along with your statement of claim. And then it's the planning part because once you have all the documents with you, you have the contract with you have the chapter plan with you can just draft a statement of claim. Then comes the drafting of the intricacies of that statement of claim. Now, how do you do it? Now, you really don't want to use a very long English sentences and draft it in a very complex language because in arbitration it's a modern law. It's not a general contemporary litigation law. It's modern law. The arbitrator to whom you are sending a statement of claim might be a lawyer, might be a retired judge, who is not really having a lot of time. Suppose I'm a practicing lawyer, if I'm an arbitrator, and somebody sends me 100 pages statement of claim. I don't have time to read on that because uh, I also have my own active practice. So it is always appreciated in arbitration that you be to the point. You don't use legal jargons and the language which often is used in your conventional style of litigation, long paragraphs and all. You use simple to the point English and just come to the point. A good statement of claim should not be more than 30 pages. That's it. I mean, unless and until it has so many facts with so many claims that you want to emphasize on, it should not be more than 35 pages. Short, crisp, and that is how you want to play it. And most importantly, a lot of lawyers even make this mistake. They feel that statement of claim is like a plaint and you have to give a list of dates. So if the dispute is of say 2 years, you start from day one and until day last and give all the description. That is not the purpose. The purpose is not to file a list of dates before the arbitrator. The purpose is to give a statement. It is a statement. If 10 events lead to certain situation, then you don't need to explain each and every 10 event. You say this happened, there was a breach, successive breaches on, you have to concise it and consolidate all these dates and events into major area. You can't be just giving description of each and every email which was being written in exchange between the parties. Now let's come to the finalization part. Of course, uh, you really, when you draft a statement of claim, you don't know tomorrow your client will tell you something, a new case, or you may have a claim which you may not want to amend it later. So it's always better to have a right to amend your claim or bring a new claim at a later stage. And regarding documents, it's always preferred to file these documents in a very organized manner. You don't want to like, I don't follow the process of doing an extra A, B, C for each document I file because in arbitration you have voluminous documents. So it's always preferred to have documents in volumes rather than each document having a separate annexure. So that is a more efficient way of filing a document, because you don't have to keep on writing an extra, because this is not as I can say, this is not conventional litigation. You don't have to annexure every document. You can file these documents in bulk by then give a page number references of the documents you file. Now next comes the statement of defense, which is a response to a claim. How do you respond to a statement of claim? Now, it's the second pleading in the arbitration. Now, essentially, it's a rebuttal of the contents of the statement of claim. And of course, under the law, you have a option of filing a jurisdictional objection under Section 16 of the Arbitration Act to say that these claims are barred by, uh, they don't have, tribunal has no jurisdiction, but that's an application which is the precursor to the main statement of defense, and that sometimes has to be decided and then you proceed. But what is exactly the statement of defense? As I told you, it's just the same as statement of claim, but your side of the story, everything remains the same. You have to just rebut the case, try to bring your point of view, and present again. There may be some documents which are not filed by the claimant in the statement of claim. So what you need to do is that you really need to ensure that your side of the story is told in a proper manner, so you file the documents along with your statement of defense. Now what are the essentials again? uh, so so for the counterclaim, because this part is something which, uh, I mean, I this is a case study, uh, how to prepare a statement of defense in particular for a prolongation claim. And that's prolongation claim is usually a claim where a party, say for a construction of an infrastructure project, is on the site and the project is delayed, and the party has to be on site for a longer time, then you know that leads to a prolongation claim. So this explains that how you have to identify if the contractor is claim idling, then you have to reply to that. So essentially, the crux of the matter is that you have to present your side of the story, and you need to make sure that uh, your documents are in line. And then, of course, as a respondent, you have an option to file a counterclaim, which is, if they have a claim against you, you can always file a counterclaim along with the statement of defense. And it is part of the arbitration agreement. It is just like the statement of claim which you are filing, but from the respondent side. Now, again, planning for a statement of defense, what are the key lists? So you need to really read the statement of claim thoroughly and read the contract between the parties to understand and prepare your defense. You can't just tell your side of the story without understanding what statement of claim, what is the nature of statement of claim which was filed. Usually, what I do while I prepare a statement of defense is that I prepare a sort of a skeletal structure, which is like an index. Okay, I will do this, write the contractual scheme, reply on this, reply. So basically, reply all on the breaches. What breaches are alleged by the contractor or the claimant? You really need to identify those breaches and then respond to it. Is it a breach itself? Can suppose the contractor say that, oh, you did not do this? Is it a breach under the contract provision? And then comes the part of parawise responses. Although in modern arbitration, you don't follow parawise responses, but in India, you still have this parawise response replying to the claims and all. Okay. So that is how it's done. And then you finalize the documentation, you footnote the documents, and you prepare a documentation which has to be followed. Don't try to overburden so many documents because you have to rely on them in the later stage. Try to keep your documents to the point and in relation to the dispute between the parties. So on statement of claim, statement of defense, and on counterclaim, if you have any questions, I can take it right now or I can take it towards the end of the session. If you guys have any question, then you can just let me know. You can raise your hands. I can just and you maybe unmute yourself and ask anything if you want right now. I will take it in the end. Okay, no questions so far. That's great. Now, let's come to the second aspect of the arbitration, which is the evidence. Now, what is an evidence? You have a pleading, you have the evidence. Now, in arbitration, as I told you in the beginning of the lecture, that Arbitration Act is not bound and the arbitration process is generally not bound by the strict rules of evidence. In India, you follow the Indian Evidence Act or you have the updated one. Now, do the statement of claim and defense follow the legal judgments as well? No, that's so there are two ways, two styles of arbitration, which is one is the style which is called as what we follow in India, where you only write facts. You don't write the law. You, of course, can rely on the legal position, but you don't rely on the case laws and say it is a settled position of law. That's part of the final arguments. Because as of now, you only have to state the provision of law under which you are relying on. And once your arbitration is goes for a final arguments, then you rely on the case laws and to prove your case, because that's when the trial is completed. You have the evidence which is recorded, you have the pleadings completed, and also you can rely on the law. The other side or other way to do arbitration is sometimes which is called as a memorial style, which is basically a lot of you have done moot courts, and there you see that the case includes the facts and the law and the legal provisions of the case law. That's a memorial style of pleadings. It is also followed in the international arbitrations, but in India we don't follow it. In at least the domestic arbitration format, we don't follow and adopt the memorial style of pleadings. We follow similarly as how in courts where you plead and file the documents, you only present the facts, and the law and the case laws comes towards the end. But yes, in memorial style pleadings, usually that's the process which the tribunal decides when the arbitration begins, whether you want to follow memorial style or the pleading style. So yes, you can do it provided it's a memorial style arbitration. Now let's come on the evidence part again. Now evidence is because the tribunal is not bound by the strict rules of Evidence Act and all. So you can decide the process you. Now in institutional arbitrations where the arbitrations are governed by some rules, you have the rules which to be followed, like say IBA rules or Prague rules or any of the rules. Otherwise, parties and the tribunal in an ad hoc arbitration can decide the way evidence is to be led. Now, what is an evidence? Now, evidence is the documentation which is to be filed along with the pleadings. Now, what happens is sometimes parties don't file all the documents. Sometimes they only file the documents which benefit them. And as a respondent or as on the other side, you don't have access to the important documents which other side may have, but you don't have it. But you feel that those documents are important for the adjudication of the dispute. That is when comes the issue of document production. You can ask the other side to produce certain documents which are in their possession. It is the same process in the CPC as well. You can ask for a discovery uh, where you can, ask for a documentation. Just to give an example, I was doing an arbitration where the contractor had claimed that because of the delay, it had suffered losses and the delays were unforeseen in nature. My defense was that this project, which was for which the claim is being raised, is part of the uh, is part of a terrain where the contractor knew the difficult terrain and the law and order situation. So the initial price was higher in nature, and therefore any losses which, if at all they are suffered, has been taken care of. In order to establish that, I had asked for a production of documents where I asked the other side to produce all the documents which they had while preparing the bid documents. And the contractor produced everything. And there we were able to prove that the contractor had already budgeted the extra cost for delay in its bid, and therefore the claim today is frivolous. So therefore, sometimes discovery really helps to in order to prove your case, in order to build that case. But the discovery also has to be in relation to the disputes which are being adjudicated. You can't ask anything under the sun. So that's how document production works. And similarly, disclosure, as I told you that, in India, in CPC also, you have the process of discovery. But what happens in arbitration, because it's a more modern way and it's a more quicker way and it's a more efficient way at times to, do the disputes and litigate the dispute. You have something which is called as a red fern schedule for discovery. What is a red fern? The red fern is named after a famous professor called Redfern and Hunter. The Redfern is considered as a modern, think, some professor of the arbitration law. So what Redfern suggested is that when you are seeking discovery for a document, you can make a table and ask for the document, give a relevancy of those documents and why those documents are uh, required. And then there can be a third column where the other side can object to why these documents should not be produced. And the fourth column can be decision of the tribunal. So it's just a format which is provided in order to seek discovery. Otherwise, I mean, you can always follow any procedure of asking for a document. But in terms of discovery, every party has a right to object to production of certain documents, and the tribunal ultimately will decide on the relevancy of those documents and accordingly give the decision. So that's the first part of evidence where the uh, party feels that there are certain documents which are being concealed. Otherwise, discovery is not usually in the regular course of arbitration that we see it every day. Now, now comes the part which is the witness. And now, what is a witness? Now, witness is once you have led your evidence, once you have filed your statement of claim, you have filed your statement of defense, and you have filed the documents. But there are certain documents which are denied by the other side. Suppose you file certain charts, you give some calculations, or those calculations are not in possession of the other side. Of course, they will say it's not a letter, they will deny it. Then you file witness statement who are the persons who are involved in that dispute who can give oral evidence. Now, what is an oral evidence? It's like a fact finding thing. Suppose there's a contract between the parties and there's a breach, but there are certain discussions which took place between two persons and it is not in the form of a written communication. Then you do a fact witness that uh, this happened, and then you cross examine that witness. And in arbitration you have two kinds of witnesses. One is the fact witness, and then there is an expert witness. What is an expert witness is, suppose you have a claim for damages. Now that expert witness will not really prove your case, but that expert witness will give a uh, detailed computation or a calculation and say this is how uh, these damages are arrived at. Suppose there's a delay uh, in a construction contract, then there will be a delay analysis expert that this is the real reason for delay. Because that expert is in the field of that area, then expert can lead it. So I'm just doing an arbitration for a pharmaceutical company, where my case is that as a manufacturer, I could not manufacture the drug because the raw material which was given to me was faulty. Now, how do you prove that the raw material is faulty in nature? My witness can say it is faulty, but there has to be an expert who can say yes, to manufacture a drug, you need A, B, C raw materials. The raw materials which were provided by the other side was not A, B, C, but A, B, and X. Therefore, because of an X, the desired results cannot be achieved. So the person is not really proving uh, what the other side did wrong. Person is just proving that raw material required is ABC, but raw material given was AB and X. So that is where the expert can lead evidence. How will the tribunal otherwise confirm that whether you require ABC or ABCX? So that's where you require an expert witness to give details on the fact which is to be proved. Just to give an example from the movies, I don't know whether you might have, all of you should see this movie. It's called as My Cousin Vinny. It's a it's a Hollywood movie where there is a lawyer. He's traveling and then he gets into some case and he has to defend it. And there he relies on some accident of a car where there comes an expert witness and says that this accident cannot be caused by this car because this car has this particular types of tires and the speed of this car can't be more than this and that. So that is where an expert witness comes and corroborates. Although it's a fictional movie, but just to get closest to what is the role of an expert witness, you all can see the movie My Cousin Vinny, where get to know what an expert witness is. Now let's come to how do you select a witness. Now it's see as a oral witness is not always necessary. You don't need a oral evidence, but sometimes there are gaps in the documentation. There are certain discussions which are only done in person. But you have to really understand that selecting a witness is the person who should be involved in that transaction. If something a dispute relates to say 2023 and you file a case in 2025 and you don't have the person who was part of doing that transaction in 2023, that is not someone who is the ideal witness. If you select someone who is not even, who suppose who joined the company today, that person is not aware because all that he knows is somebody who's telling him. So that's not the right witness in such scenarios. And of course, the witness job is not to plead the law. It is only on the facts. That what is the facts? What did he or she saw? What did he or she understood of the dispute? Not the law. The law is the job of a lawyer, and the interpretation of law is the job of the arbitral tribunal. As a witness, your job is to only stick to the facts. Then, as I told you, witness of fact can only determine what are the facts and disputes. Then as a witness of as an expert witness, as I told you that you can have an expert witness say in construction disputes. You can have an expert who can tell you what are the construction practices, what are the usage. Say you have a dispute for a building, for a bridge which is destroyed. Can an expert give a witness that whether these designs were faulty or not? Yes, expert can lead evidence that the design of the bridge was faulty. And there may be the other expert who will come from the other side, say the design was not faulty. And then basis the evidence given by both of these experts, the tribunal comes to a conclusion that whether, you know, who is right and who is wrong. And then in arbitrations, especially in international arbitrations, you also have an expert on foreign law. Suppose there is a dispute, an arbitration, which is uh, seated in London or Singapore, which is based on, which is based on from the Indian law, but the tribunal is a foreign uh, arbitrators and all. How do they determine what is the right position of Indian law? Because they are deciding the issue on an Indian law. Then you have a expert on Indian law as well. We did a, I did a Singapore SIAC arbitration where we had a former judge of the Supreme Court as an expert witness on Indian regulatory law and even a former RBI senior officer to give understanding on what is the RBI regulations on a particular aspect. So you, of course, you have legal experts and all who can be the expert witness. And then you have valuation experts, you have medical experts, you have accountants. So it's a expert reports is prepared by these witnesses, and then that is seen. Now comes the last aspect, and we have just a few time which is left for. You have a witness, the witness has given an affidavit or the witness statement. Now you cross examine the witness. What do? You cross examine checking the person's credibility. If the person is, as I told you, not part of the transaction, you can say, were you part of the transaction which took place in 2023? You say no. And that witness is anyway not credible in nature. You can't rely on the testimony of such witnesses. So the object of cross-examination is that you have to kill the credibility, attack the credibility of witness, and question that whatever facts you are stating is wrong in nature, and that's you're wrong. So your testimony should not be accepted by the arbitral tribunal. And then again, checklist for cross-examination is uh, you can't really ask anything under the sun. You have to be courteous in nature. You have to be respectful for the witness, and you have to make sure that you don't ask questions which implicate you or let the witness improvise or improve their answers. And that is why you don't should not allow explanations, because that's cross examination is only usually in the form of yes or no, not more than that. So those are the checklists that you need to follow. So yes, we have. I mean, I've been able to finish quite a long topic in. I mean, the time was less, but let's see. Uh, this was really helpful. I'm sure that it was a bit of a rundown session, but I would expect any questions you have, because we still have 12 minutes to end this session, and whatever questions you have, I'm happy to answer them. Yes. Any questions, you can text, you can type it in the box, and then I can answer them, or maybe you can just raise your hands and we can have a short interaction before the session. And
Sir, there are few questions in the text box. Would you like me to read them for you?
yes, let me just figure it out.
So, sir, first question is, sir, any individuals is allowed to practice as sole arbitrator or not, both domestically and internationally?
Yes, you can be an arbitrator. I mean, there is, uh, you just have to, suppose you have to be nominated an arbitrator, for example, by Delhi High Court. So you have to be, either you can be on the panel uh, of the IAC, and as an arbitrator, usually, if parties have selected you, then you can be an arbitrator. There's no bar to it.
Thank you, sir, for answering. Should I state another one?
Yes.
So it is, do the statement of claim and defense contain the legal argument as well, including case laws and judgments?
That I've already answered that, in a memorial style of arbitration, yes. But if it is not a memorial style, it's a pleading style of arbitration, then no. You can state the provisions of law, like maybe the provision under which your claim is there, or section of the particular provision. But you cannot really rely on the case law, because that happens in the final arguments, where you can rely on the law. Otherwise, it's only restricted to the facts of the case.
Thank you, sir. The next one is, sir, when you are drafting a defense to an EOT claim, how do you personally decide whether to strongly contest the delay or take softer, neutral approach using document like RA bills? Does it depend on the tribunal or a strategy?
Can you just read that question slowly, because or
Sure,
maybe
sir.
I'm not able to see where these questions are. Is there in call messages? Okay, I'll just read it from there. So when you are drafting a defense to an EOT claim, how do you personally decide whether to strongly contest the delay or take a softer neutral approach using documents like RAs? Does it depend on the tribunal or your strategy? So in EOT claims, essentially it's EOT means it's an extension of time claim, where a party is seeking further extension of time. And usually these disputes go in when the claims is rejected, because that is when the arbitration starts. Uh, so as a lawyer, when you're replying to an EOT claim, you basically need to see the justification which has been given by the engineer of denying those claims. And Uh, and you may need to see that if the delay is attributable to the contractor, then no EOT can be granted for that time period. So that is where you have to see the breach of the contractor rather than anything else in order to determine such claims. Uh, then we have question. Jim Parekh has asked, so what is the significance of an expert witness and an expert arbitrator in the subject matter is there in the tribunal? Of course, the expert witness role is to present your side of the story because, as I told you, only an expert can tell what ingredients are to be required, whether those ingredients are only sufficient to manufacture a drug or not. And that is when, because your arbitrator is an expert in the subject matter, the the uh, the expert witness would be able to convey the technicality so that the arbitrator can understand. Then we have the question from uh, what is the difference between ad hoc tribunal and the what is the difference ad hoc and the institutional arbitration? Now, ad hoc arbitration is something which is the parties decide the rules, the parties decide everything, the process and the procedure which has to be followed, and then the consent of the arbitrator. And of course, in the institutional arbitration, you have well defined rules about how things are to be done, and how procedure is to be conducted, the manner in which the documents is to be filed, whatever, whatsoever. So that's the difference between institutional arbitration and the ad hoc arbitration. And especially in institutional arbitration, the presiding arbitrator, the arbitrator is usually appointed by the institution itself, depending upon the nature of the dispute. So you write to the institution saying that for a sole arbitrator that I have a dispute, please appoint someone. They appoint you. Then institution arbitration has several benefits as well because there are there is a tribunal secretary, the institution manages the arbitration. At 10 times, the awards are even reviewed by the institution. So there's a strict timeline which is followed. In an ad hoc arbitration, it is all depends on the consent of the parties and the arbitrator that you have. Sir, if the goods are delivered by us, but after delivery or during the course of delivery, due to other parties' negligence, the goods get damaged. Can we practically prove during arbitration that it wasn't our fault? What kind of documents or testimony would be important and effective in such cases? See, in such cases, what you need to show is that once you delivered the goods, those goods were accepted by the other side. And mostly all these in delivery of goods, you have something which is called as a delivery challan. Once you deliver the goods, they accepted the goods. If they do not raise any dispute at the time of acceptance of goods, and if these delivery challans are signed by the other side, then you can always say that, look, that time there was no dispute. After that, the goods got damaged, and that is not my fault. I had delivered the goods, and usually in such cases, you have that, the contract says after the delivery, you can't raise it, and any dispute or any inspection is to be done at the time of taking the delivery. So that is those delivery challans and all are very important in proving such a case. Snigdha Bhattacharya says the contract between the parties clearly specifies that all communication will be in writing. Documentary evidence are produced. Respondent denies that certain documents. So, how to prove the document? How does the oral evidence come into picture regards to the proving contents of the document? So, what is an oral evidence? Now, suppose I write an email to you and you deny that email. Of course, you can't deny a document. The contents of the document is not something which they speak for themselves, right? So you don't have to really focus on proving the contents. Otherwise, all the documents would be denied. Contents would be proved if suppose an email which is denied by the other side. You just give a background that this email was written because a letter may not give the background in nature. A letter will just be the conclusion at times. So you give the background that this was the email written. This email was written in furtherance to previous other emails, which was is on record. So basically, you corroborate your case and give that evidence in the form of explaining the background of that email. Distinguishing factors between plaint and the SOC. It's very, see, SOC is just in arbitration, the plaint is before the court. So it's the same. It's just that statement of claim does not really follow the strict principles of CPC. So otherwise, it's the same thing. That it's the same thing. It's not different. It's just the different forums in which you are presenting that case. So uh, that's about it. Uh, and then you also have one question that how can academics help in getting into the field of arbitration? Of course, as an academician, the more because arbitration is all about something which you can always practice, even if you're not if you don't regularly go to courts because it's more like a private dispute. So understanding more about the procedures and especially the damages and contract because most of these disputes are contractual breaches. So someone who is having a very deep understanding of the regulatory law or someone who is having a very good understanding of the commercial aspects of the law can really get into the field of arbitration. And of course, you can be considered as an expert witness in the arbitration. You can also be considered as an arbitrator. So that all depends on the experience and what kind of specific. So it's all about the niche field. So if you have a niche or something specifically in the commercial law, then of course you would be considered maybe as an expert witness or an arbitrator to resolve or specialize dispute. Uh, I think that's it for today. Um Thank you so much, everyone, for a patient 1 hour hearing. And I hope that all of you have learned some tips for the arbitration. If you want to be an arbitration lawyer and how do you want to proceed it. And even if you're interning, even if you are going to practice law, I think this session would have some bearing on you in terms of helping you how to strategize the case, how to read a document, how to prepare, how to look for the evidence, how to look for the documentation. So thank you so much once again, and have a great day. I hope.
Thank you, sir, for sharing your remarkable knowledge and experience. Moving ahead, we are truly privileged to welcome Mr. Laltak Joshi, an accomplished advocate on record at the Supreme Court of India. Mr. Joshi brings nearly a decade of experience in commercial litigation and government advisory. A graduate of Symbiosis Law School, Pune, he has represented clients before the Supreme Court and the Delhi High Court, showcasing his expertise in complex legal matters. His tenure at JSW Steel further enriched his understanding of corporate legal frameworks. Mr. Joshi's dedication and proficiencies make him a distinguished figure in India's legal landscape.
So kindly join us.
Hi, I'm online. Thanks, area committee, for being so generous with their words. Good morning, everybody. Hi, I'm Laltaksh Joshi. The topic for today's discussion is going to be understanding the grounds to challenge an arbitral award. I would try to have a discussion with practical examples. So, without uh, making much ado about it, let's dive in straight into the topic. I would try to keep the discussion around a case study in the case of Union of India versus Reliance Industries. It was widely reported in the newspapers. The judgment was passed earlier this year by the division bench of the Delhi High Court. And because it was reported so widely, mostly in all the business newspapers, some of you may already know about it. The reason of shortlisting that particular case as opposed to others, one, because it's very recent. Second, because there are few judgments which eventually set aside an arbitral award. As some of you or all of you may already know, the grounds to challenge an arbitral award are very narrow, and courts are generally very circumspect in setting aside an arbitral award. So this judgment not only discusses the law, but eventually sets aside an arbitral award. So it will give a good flavor of uh, blending the law with the facts of a case. Eventually, we have to argue on the basis of facts of a case. So if anybody of you wants to read the judgment, it's the citation is 2025 SCC Online DEL 841. Now, you see, in this case, the arbitral award was passed way back in 2018. A Section 34 petition under the Arbitration and Conciliation Act came to be filed by the Union of India because the arbitral award was passed in favor of Reliance Industries. And I'll give the factual background and then we'll blend the law with the facts. The Section 34 petition filed by the Union of India was rejected by the Delhi High Court recently in 2023, whereafter the appeal under Section 37 of the Arbitration and Conciliation Act was filed by the Union of India because the Section 34 petition was dismissed. Now, the judgment passed in the appeal under Section 34 of the Arbitration and Conciliation Act is going to be the foundation or the edifice of today's discussion. Now, the factual background goes thus. In 2000, Union of India enters into a production sharing contract with Reliance Industries Limited. And so there was a participating interest for Reliance and Nico. Nico was the uh, partner of Reliance for this project. Now, the project was for exploration of natural gas from the Krishna Godavari Basin, the KG Basin, popularly known as the KG Basin, or specifically KG-D6, because I remember reading about it way back when the contract was entered into. It was reported all over the papers. Now, the crucial factor was the location of the reservoirs, as they call it. It was located at 19/3 off the coast at Andhra Pradesh. Now, why is that important? Because simultaneously, the Union of India also executed a production sharing contract for exploration of natural gas with ONGC for a unit located in KG Basin at 98/2. Now, KG Basin, as some of you may know, is one of the largest natural gas discoveries in India. So it was a very, very big deal back then. And even today, the gas explored from it, is used for various purposes such as power generation, fuel, fertilizer production, so on and so forth. So the stakes involved are huge. Now, both the blocks of the ONGC and the Reliance, they turned out to be adjoining, which led to, so for better understanding, let's keep one block as Reliance block, the other as ONGC block. Now, insofar as the Reliance block is concerned, the preliminary results about the original gas in place, which were there, the original gas found in the reservoir, that was prepared by a company called J. Goyler and McNaughton. For the to save ourselves from getting distracted with the pronunciation, let's call it DM because we'll come back to it again. This preliminary report was followed by a final report and subsequent reports every year in 2003 to 2004, 2005. Now, while the preliminary and final reports were shared by Reliance with the Union of India, the two parties to the contract, the subsequent DM reports of 2003 particularly was not shared with the Union of India. And that will be of some bearing when we blend it with the grounds stipulated under Section 34 of the Arbitration and Conciliation Act. Now, thereafter, the development plans were submitted by Reliance, which were approved by the Union of India in 2009. And eventually, Reliance commenced its commercial production of natural gas in the Reliance block. The exploration was within the contract area, and that will also be of some relevance as we go along. Now, the genesis of the dispute between Reliance and the Union of India that lied in a letter dated 22nd July 2013, written by ONGC to the Union of India. And what was stated therein that there was evidence of lateral continuity of gas pools inter, say, Reliance block and ONGC block, which means that the block were interconnected to the extent that there was migration of gas from the ONGC block to the Reliance block. And please understand, the Reliance was exploring gas within its contract area. So they were working within the contract area, but the gas from the adjoining block in ONGC was getting migrated to the Reliance block. Now, this letter resulted in ONGC filing a writ petition before the Delhi High Court, claiming that Reliance has been unjustly enriched by producing and selling the gas that migrated from the ONGC block. Now, this led to complex issues, complicated situation, something for which there was no precedent because there had not been a situation like this in the past. Now, what was the outcome of the writ petition? Because this is all in the past before arbitration even began. During the pendency of the writ petition, ONGC and Reliance they entered into an agreement for project management of independent third-party study. Without prejudice, of course, to their rights, they appointed the same DM to undertake an independent third-party study of the alleged migration of gas. Now, because both the parties, both the contractors, so to say, they agreed to get an independent third party examination about the connectivity of the reservoirs, migration of gas. So, the Delhi High Court disposed of the writ petition in 2015 with the direction to the parties that they will cooperate with DM for study of migration of gas. And that Union of India was thereafter given liberty to take a decision about the issue of alleged migration of gas. Because DM would, of course, submit its report on which the Union of India will take its decision. And of course, the Delhi High Court also directed that whoever would be agreed can always come back to the court or can invoke its remedy in accordance with law. Now, in 2015, DM submitted its final report indicating connectivity of reservoirs and migration of gas. Now, DM in its final report indicated, and this is very crucial, that there was connectivity of reservoirs or in the ONGC block and the Reliance block, and it also indicated that there was some migration of gas. Now, this crucial report, read with some other facts which we'll come to, led to Reliance invoking arbitration. Why? Because the DM report was submitted to the Union of India. Union of India, in order to, like I said, there has been no precedent about such a case in the past. So Union of India formed a committee of Justice AP Shah, and Justice Shah committee had to consider the DM report and then recommend the future course of action. That now that there is an indication of connectivity of reservoirs, what really happens, because both the companies had been exploring gas within its contract area, but there had been some migration under the ocean from one reservoir to another. Uh, Now, based on Justice Shah's report, which was submitted to the Union of India raised a demand to the extent of 1.5 billion USD upon Reliance, which is huge now for a group. Now, that demand came to be challenged by Reliance in arbitration proceedings. Reliance invoked arbitration, and an arbitral tribunal, as per the arbitration agreement contained under the production sharing contract, was constituted. Uh, Reliance, in their statement of claim, sought various declarations that, for instance, there were some 12 or 13 declarations, primarily being that the contractor, Reliance and Nico, and eventually there was another party, British Petroleum, in favor of which Reliance had given up some participating interest. And why these details are relevant will also become clear at a later point in discussion. Now, Reliance invoked arbitration. It sought declaration that contractor, which is Reliance Nico British Petroleum, produced gas from within its contract area, and that it has a right to produce all the gas in its contract area, even if some gas migrated from the ONGC block. So it is entitled to retain all the costs and profits resulting from such extraction. And it also sought a declaration that, look, Union of India has no right to restitution and it has not suffered any injury from the contractor's production of gas, which had migrated to its reservoir, allegedly from the adjacent ONGC block. Now, the arbitral tribunal comprised of three members, as I had mentioned, and the arbitral award, which was passed in 2018, it was passed in favor of Reliance by a 2:1 majority. Now, this case presents a very interesting fact insofar as an arbitral award is concerned, because the practitioners get to see both sides of the coin with a dissent award in place. The case presenting both opinions, majority as well as dissenting minority award, will give a flavor of both sides of the coin to show why Reliance argument is right and why Union's argument was also correct. Now, the majority of the arbitral tribunal held that there was no express prohibition against Reliance from extracting migrated gas within its contract area. Why I keep saying within its contract area? Because the exploration was not going the beyond the contractually obligated boundaries. For example, some of us may have come across news about mining, or rather illegal mining, where the contractors given license to mine a particular mineral within a confined boundary during mining go beyond the permissible boundary. Now, unlike that scenario, this is a situation where the exploration was happening within the contract area, but underneath the ocean, because the reservoirs go deep into the ocean, underneath the ocean, the gas was getting migrated from an adjacent block. Now, the majority of the arbitral tribunal held that there is no express prohibition against Reliance from extracting the gas from within its contract area. It was also held that terms of the contract and the petroleum and natural gas rules make it explicit that Reliance was permitted and it was required under the law to extract all the available gas within its contract area. It did not need any further permission. Now, one important aspect which fell from the majority award, which will be of some importance as we go along and examine the judgment passed by the Section 34 court, and mostly and most importantly, the Section 37 court, is that the majority arbitral tribunal held Reliance was contractually obligated to share and disclose a 2003 DM report. That same DM had given a report in 2003 that there was some indication of connectivity between the two blocks. And as I had mentioned earlier, that the report of 2003 given by DM was not shared with Union of India. So the majority arbitral tribunal held that while non-disclosure of the 2003 DM report was a contractual obligation under the production sharing contract upon Reliance to give it to the union, but because it was not a material breach, so there was no consequence attached with the non-disclosure insofar as the majority arbitral tribunal is concerned. Now, another pertinent factual finding returned by the majority arbitral tribunal was that there was connectivity of reservoirs and gas produced by Reliance, included gas which had migrated from the ONGC reservoir. It had returned that factual finding, but again attached no consequence with it because eventually the majority held that A, there was no express prohibition against Reliance from extracting migrated gas within its contract area, and B, it did not require any permission from the union, any further permission once the production sharing and exploration agreement is in place. Now, the dissenting award concluded that under the production sharing contract, if the reservoir extends beyond the block boundaries, then Reliance may either seek permission to enlarge its development area. Now, this is very important. Please understand. The minority, on the other hand, concluded that if the because of connectivity of the reservoir, if the reservoir of Reliance extends beyond the block boundaries, then either Reliance seek permission to enlarge its development area or jointly develop the area with ONGC or relinquish its right to such reservoir. So, as opposed to the majority tribunal holding that Reliance extracting and exploring natural gas within its contract area from this ocean required no permission, the minority said that look, the reservoir eventually extended beyond the block boundaries, and therefore either Reliance had to seek permission or jointly develop the area with the contractor of the adjoining area, that is ONGC. Now, whatever please understand, whatever I'm presenting are, these are crude facts. This is, of course, I'm not giving my opinion, these are crude facts. Now, the minority arbitral tribunal gave a reasoning that there can be no effective lease or enjoyment of an area covered by a reservoir, that is ONGC's enjoyment of its own block cannot be an effective enjoyment if such reservoir is being drained by a different entity on its block boundary, that is Reliance. It was also, of course, now the common, this was so far as the distinction is concerned. It, insofar as the non-disclosure of the 2003 DM report is concerned, even the minority held that non-disclosure of the DM 2003 report was a breach of the contract. This is a common finding. While the majority held this was not a material breach, the minority held this was a material breach. Why? Because it indicated some connection between the reservoirs. Now, this award eventually was challenged by the Union of India before the Delhi High Court under Section 34 of the Arbitration and Conciliation Act. Some of you may have read the Section 34. I would urge that the ones who haven't, please read Section 34 of the Arbitration Act over and over again, multiple times, because every time we tend to discover something new or have a new perspective to the same section. Now, coming back to the case at hand, Union of India challenged the arbitral award under Section 34 of the Arbitration and Conciliation Act. The ground uh, urged by the Union of India was that this non-disclosure of 2003 DM report was a material breach, because had the 2003 DM report been disclosed contemporaneously way back in 2003, the Union of India could have taken a decision to jointly develop the area with ONGC. Because it was not done, Reliance had unjustly enriched itself. And this aspect, which was well observed by the minority arbitral tribunal, was missed by the majority. And this had resulted in patent illegality under Section 34 of the Arbitration Act. And this was also against the not just the fundamental policy of Indian law, but also against the most basic notions of justice. Now, these expressions are expressly mentioned under Section 34 of the Arbitration and Conciliation Act. And in today's discussion, we are going to understand what each of these really mean in the facts of this case. So we'll understand not just uh, making the meaning of these expressions verbose, but we'll try to blend the meaning of all these expressions with the facts of the Reliance KG Basin case that we have just understood. Now, the petition under Section 34 of the Arbitration and Conciliation Act came to be dismissed by the Delhi High Court with the following reasons. One reason given by the Section 34 court was that the arbitration between Union and Reliance was an international commercial arbitration, and therefore the ground of patent illegality was not available. Now, why was it held that it was an international commercial arbitration? And this is a very important fact insofar as the practical aspects to arbitrations are concerned. Now, as you may be well aware, that if one party to the arbitration happens to be a foreign entity, then the arbitration proceedings under Section 2 of the Arbitration and Conciliation Act does not remain a domestic commercial arbitration. It becomes an international commercial arbitration. And the distinction between the two is that the grounds under Section 34 of the Arbitration and Conciliation Act to challenge an arbitral award are even narrower in international commercial arbitration. Some of the grounds, such as patent illegality, is not available to challenge an international commercial arbitration award, which otherwise is available to challenge an award passed in domestic arbitration. Therefore, this issue assumes so much importance whether the arbitration between Union of India and Reliance was a commercial international arbitration or a domestic arbitration, and it became a preliminary issue before the Delhi High Court in the Section 34 judgment. Now, insofar as the non-disclosure of the 2003 DM report was concerned, the court held it was not a material breach. Reliance was operating as a licensee with a limited role to explore and extract natural gas within its contract area. Now, broadly in view of these two observations, the Section 34 petition filed by the Delhi High Court filed by the Union of India was dismissed. Now, the judgment of the Delhi High Court in Section 34 was challenged in appeal under Section 37 of the Arbitration and Conciliation Act. I will just take a minute to, for those of you who don't know, the practical side to the arbitration practice is that an arbitral award is challenged under Section 34 of the Arbitration and Conciliation Act. It has to be challenged within a time fixed period, that is 120 days, or rather 90 days plus a grace period of 30 days, which can be condoned subject to sufficient reasons. Now, this time period has been held to be, I'm slightly deviating from the topic just to give this important information about the practical aspect. The arbitral award has to be challenged within the fixed 90 plus 30 total 120 days period. Whereafter, it can't be challenged at all. The courts have held that this period of 120 days is strict. An arbitral award cannot be challenged even on the 121st day. It will be simpliciter dismissed on the ground of limitation. Now, the challenge to an arbitral award lies under Section 34 of the Arbitration and Conciliation Act. The final decision passed in Section 34 can be appealed under Section 37 of the Arbitration and Conciliation Act. The final order passed in Section 37 of the Arbitration Conciliation Act can be challenged only by way of SLP before the Supreme Court. So this is the hierarchy. Eventually, the final adjudication or the final remedy rests with the Supreme Court by way of a SLP. Of course, with reviews in between, that's a different matter on very limited grounds. Now, coming back to the present case, Union of India challenged the judgment passed by the Section 34 court in appeal under Section 37 of the Act and argued that, look, Union of India's main argument was that migrated gas is a vital natural resource, being natural gas. it vests with the Union of India as a trustee of the people of the Union in accordance with the public trust doctrine. And therefore, this award was in conflict with the public policy of India. Now, this argument is very important to understand. So I'll repeat for a minute. Union of India's case was that natural gas, being a vital natural resource, vests with the Union of India as a trustee of the people of the Union, in accordance with public trust doctrine, and therefore the award giving permission, so to say, to Reliance to explore that gas from the connected block would be in conflict with the public policy of India, because under Article 297 of the Constitution of India, the Union being in acting as trustee of the people of the Union has ownership of all the natural resources, and those can't be extracted by a private entity without the permission of the Union. And Union of India never gave Reliance permission to explore gas, which had migrated from the connected block. Now, under the production sharing contract, there was no authorization from the Union of India to Reliance to sell migrated gas from the ONGC block. The Union also made submissions for a non-disclosure of the 2003 DM report and termed it as a material breach of contract, and all that was also raised. Now, it was lastly argued that non-sharing these material information with the Union, it was also in conflict with the most basic notions of justice, which constitutes a ground under Section 34. Now, the reason of saying so by the Union was that the same reasoning going back to Section 34 argument, that had you shared this information with me, and Shambhavi, I'll just come back to your question in some time. Uh, that's right. And I'll come exactly to this question because I'll discuss the Section 34, 37 judgment in detail. So we'll get to know against public policy can be practically assessed in the facts of a case. Now, coming back to the case at hand, Reliance submission, on the other hand, was that look, there is nothing wrong with the arbitral award insofar as non disclosure of the 2003 report is concerned, because that could at best result in a situation where the Union of India could have ordered a joint development. Now, Reliance submitted a very significant or a very interesting aspect to the case. It said that, look, when the writ petition was filed by ONGC, the Union of India had itself filed a counter affidavit or a reply, so to say, in the writ petition. And in that reply, the Union had contended that ONGC was not ready. It was far behind development in the ONGC block. So the Reliance submission was that non-disclosure of 2003 report would at best result in a situation where the Union of India could have ordered a joint development, but because ONGC was not ready, according to Union of India itself, there was nothing wrong in non-disclosure of the 2003 report, and there was nothing wrong insofar as the Section 34 grounds are concerned. Now, the division bench, before going into the meaning of public policy, most basic notions of justice, morality, so on and so forth, they dealt with the preliminary issue of whether it was an international or a commercial or a domestic award, because that would, as we have discussed, open up the ground of patent illegality as well. The division bench of the Delhi High Court observed that arbitral tribunal had itself recorded a factual finding of only Reliance being the claimant in the arbitral proceedings. Neither NICO nor British Petroleum was a claimant in the arbitration proceedings. And this factual finding was never challenged by Reliance by way of a Section 34 petition. Therefore, that factual finding attained finality. Now, once the arbitral tribunal returned a factual finding that claimant was Reliance, which happens to be Indian entity, the respondent was Union of India. Therefore, this has to be deemed to be a domestic arbitration and not an international commercial arbitration. Now, moving this preliminary issue out of the way, it was clear before the division bench that there would be three grounds to be dealt with and see whether the arbitral award falls in either of these three grounds, namely patent illegality, fundamental policy of Indian law or the public policy of India, and thirdly, most basic notions of justice. Now, insofar as the law or the meaning of these three terminologies are concerned, we'll go through each of these one by one. What is patent illegality? The court observed, and it cited judgments passed by Supreme Court in state of Chhattisgarh versus Sal Udyog, Sangyong, so on and so forth, which all of us, it gives a good reading, and all of us can Google these judgments by the name Sal Udyog, SAL Udyog, and by the name Sangyong, and it gives for a good understanding of the subject. The court in Reliance case relied upon state of Chhattisgarh versus Sal Udyog and observed what would constitute patent illegality has been elaborated in Associate Builders versus DDA, which means that either a substantive law of India is contravened, and that contravention goes to the root of the matter. For instance, a provision of for example, provision of the uh, Contract Act is contravened, or and giving an example, a specific example. For instance, Section 73 under the Contract Act and 74 of the Contract Act stipulates that to prove or to seek loss of damages, claim of loss and of damages and losses, they have to be actually proved by leading evidence. And for example, an arbitral tribunal awards losses and damages under Section 73 of the Contract Act, despite observing that a claimant had not shown or established any actual loss. So that would be held to mean a contravention of substantive law of India. Why? Because that contravenes Section 73 of the Contract Act. So that constitutes a ground under patent illegality. Now, what further is meant by patent illegality? The court, in this case, reiterated, in the case of Reliance, reiterated that a finding either based on no evidence or an award which ignores vital evidence in arriving at its decision would be meant to suffer from patent illegality. Now, giving a practical example, and in fact, building on the same example of claim for losses or damages, for instance, in the same example, because the arbitral tribunal had recorded that claimant is entitled to losses or damages, despite not having established actual loss, would show that award is based on no evidence. So it would constitute patent illegality. What further comes within patent illegality is if an arbitral tribunal does not decide the dispute within the confines of the agreement. Now, an arbitral tribunal is unlike the conventional civil courts. An arbitral tribunal is constituted within an agreement. So the genesis of an arbitral tribunal happens to be in the contract or the agreement. So it has to act within the confines of the agreement. Sure, the interpretation of terms of the contract lies within the domain of the arbitral tribunal, and courts generally do not interfere with the interpretation of the terms of a contract given by arbitral tribunal. But if other grounds are met, then courts surely interfere. For example, in this case, whether the disclosure or non-disclosure of the 2003 DM report by Reliance to Union of India constituted a material breach or a not material breach under specifically Article 26 of that agreement, the court would not interfere with the interpretation of the arbitral tribunal. And we'll see the ground on which the court had interfered. Now, coming to the next, what is really meant by, as Shambhavi had put, public policy of uh, law or fundamental policy of Indian law. The court in this case held that look, the fundamental policy of Indian law would mean the same as understood in para 18 and 27 of associate builders, which means disregarding orders or judgments passed by superior courts in India. For example, contravention of Arbitration and Conciliation Act would also constitute contravention of fundamental policy of Indian law. Giving a practical example, for instance, an arbitral tribunal passes an arbitral award, but this does not give an. I'll give a better example. For example, an arbitral tribunal passes an arbitral award on 10 claims, and for 8 of those claims, give no reasoning. Therefore, such an award for those 8 claims would be held to contravene fundamental policy of Indian law because Arbitration and Conciliation Act under Section 31 makes it mandatory for the arbitral tribunal to give reasons with the award. And if there are no reasons given in the award, then that would contravene fundamental policy of Indian law. Now, moving on to the meaning of third ground for the purposes of this case, that what is really meant by conflict with most basic notions of morality or justice. Now, the court in the case of Reliance relied on Sangyong versus NHAI. That's a landmark judgment by the Supreme Court passed in 2018-2019. And court reiterated that most basic notions of morality or justice as held by the Supreme Court in Sangyong's case would mean as understood in para 36 to 39 of associate builders case, which means that an award which shocks the conscience of the court. Now I'll explain that with an example. For example, a claimant seeks in arbitration in the SOC, in the statement of claim, raises a claim of say 10 lakhs. But the arbitral tribunal awards rupees 20 lakhs without any reason. And when I say that, it may sound yeah, unbelievable to somebody like me in the first row, but because we have seen these kind of instances and we've seen these kind of awards, so these kinds of awards has been passed in the past. So an arbitral tribunal passing an arbitral award for 20 lakhs, despite a claimant seeking only 10 lakhs from the arbitral tribunal in the statement of claim, and the arbitral tribunal giving no reasoning, would be held to be in conflict with the most basic notions of justice. Why? Because justice demands that the resolution of a dispute has to be what is prayed for by the parties. Justice without reasoning cannot go beyond what is prayed by a party. So, a award which shocks the conscience of the court would fall within the ground of being in conflict with most basic notions of justice. Now, applying these three principles of patent illegality, fundamental policy of Indian law, and most basic notions of justice and morality to the facts of the present case, the court observed that the award passed by the majority constituted patent illegality because as I had mentioned earlier, Article 297 of the Constitution of India uh, observes and stipulates that Union of India is a depository holding the natural resources of India as a trustee for and on behalf of the people. So the court relied upon Article 297 to say that the award passed by the majority constitute patent illegality because it contravenes substantive law in India, that is Article 297. The court cited another judgment by the name MC Mehta versus Kamal Nath to observe that the majority award was contrary to public trust doctrine. Now, what is public trust doctrine? Uh, Public trust doctrine, it primarily rests on the principle that certain resources like air, sea, water, forest, natural gas in this case, they have a great importance attached to the people of the nation as a whole, and it would be unjustified to make them subject to private ownership. So, in the court's considered opinion, the observations weigh the implicit permission by the Union of India of the migrated gas made by the majority award needed some consideration because the majority award had, and I'll quote this portion because that will show how the court did not wander outside the arbitral award but stayed within the uh, uh, judgment and reasoning of the arbitral award to find grounds to interfere under Section 34. The exact portion recorded by the arbitral award was, and I'll quote, unless such an order is made, the claimant is not prohibited and is permitted to continue its petroleum operation within its contract area in a situation where reservoir extends beyond its contract area into another. So this observation by the majority that the reservoir extends beyond its contract area into another was held to suffer from patent illegality because it contravened Article 297 of the Constitution of India. The courts held that gas migrating from ONGC block cannot be extracted solely to the benefit of Reliance because for it, it had no permission. One more aspect I would like to highlight here, and I may I may have wondered about it. A question comes to my mind: are the grounds under Section 37 and 34 of the Arbitration Act common, or is the scope for interference under Section 37 of the Arbitration Act different from Section 34 of the Arbitration Act? Because this issue was also reaffirmed in this judgment, and the court held that the grounds to adjudicate a Section 37 appeal are the same as the grounds stipulated in Section 34. Namely, that the Section 37 court also has to see an arbitral award from the viewpoint of the grounds stipulated under Section 34 of the Arbitration Act. So, the court, after discussing the law, and we are towards the final leg of our discussion, so if any of you have any questions, I'll be happy to address each of those questions. Uh, The court, after discussing these three grounds, after observing Article 297, the court only looked at the arbitral award and held that it's apparent from the findings of the tribunal that Reliance was in breach of terms of the production sharing contract because it failed to disclose the 2003 DM report, which, if you remember the earlier part of our discussion, the 2003 report had indicated some sort of connection between the ONGC block reservoir and the Reliance block. So the court held that failure to disclose the 2003 DM report was in violation of Article 26 of the contract. And there was a clear suggestion that, and even the court even relied on the 2015 DM report, which was the result of the agreement between ONGC and Reliance in the writ petition. Now, you see, there is no, the court also arrived at a observation that there was no analysis or there was no finding by the arbitral tribunal with respect to the aspect of the shifting, and this is very important, shifting stands of Reliance. Because at one point in time in the writ petition filed by ONGC, Reliance had admitted to the connectivity of reservoirs. Now, why I highlight this fact, we have already discussed, you see, the grounds under section 34 and 37. Why I highlight this particular fact is because end of the day, we lawyers have to really read each and every document to the last dot. And this is something, the arbitration going on in 2017, for the lawyers to read the reply filed by Reliance in 2014 shows that everybody was working very meticulously, and that is why this detail could be borne out and presented for the consideration of the court. And eventually, the court also found merit in this submission that way back in its reply in the writ petition, Reliance had admitted to the connectivity of the blocks. So, if there is an admission by a party to the connectivity of the blocks, then surely it has to be attached with certain consequences. And one party cannot be permitted to benefit from the exploration of gas fully. And the division bench concluded by saying that because of Article 297 of the Constitution of India, because of non-disclosure of the 2003 DM report, because of the admission of the Reliance in the reply to the writ petition, it felt that the view taken by the arbitral tribunal was not a possible view and deserved to be set aside in view of the public trust, predominantly in view of the public trust doctrine, in view of it being conflict with public policy of India, in view of contravening uh, uh, substantive provisions uh, of the law in India, constituting a ground under patent illegality. And the judgment of the court passed in Section 34 of the Arbitration and Conciliation Act was set aside, and so was the arbitral award. I hope that brings me to the end of my session. I hope uh, the participants uh, benefited or were able to put some meaning to the definition of the expressions used in Section 34, namely what is really meant by patent illegality, uh, what is really meant by public policy of India. And I hope this would help the participants in understanding the grounds uh, prescribed under Section 34 of the Arbitration and Conciliation Act. I thank uh, Amity Law School for giving me this opportunity, and also the DoJ ProBono Club and the ADR committee and Shobita for coordinating it so well. Let's see the questions. Shambhavi says, since the grounds under Section 34 and 37 are the same, how is it possible that a ground was not contested at the Section 34 stage? It can still be raised during the Section 37 appeal. Could you please share an example where this was allowed? So, this was an objection raised by Reliance in the Section 37 appeal that the arguments or submissions of union in the Section 37 stage were not raised by the union in the Section 34 stage. And in response, the Union of India showed pleadings from their statement of defense filed in the arbitral tribunal, showed their Section 34 petition, and established that all the grounds urged by it in the Section 34 petition, in the Section 37 appeal, were in fact pleaded by them in the arbitral tribunal as well as in the Section 34 stage. You see, that is why a cardinal principle for drafting is that a lawyer must take all the grounds in the petition, and then it is, at the to be decided uh, by the lawyer or by the counsel arguing the case to pick which one out of the 10 to present for the consideration of the court. So that at a later point in time, if an objection like this is raised, it can always, be pointed back to the pleadings and shown that the points which are now being contested were pleaded. Now, that's insofar as the principle for drafting is concerned. Now, there are certain scenarios where a ground raised by a counsel while arguing is not taken in the Section 34 stage. Assuming a scenario that this argument adopted in Section 37 appeal was not taken in the Section 34 petition. Now, insofar as that scenario is concerned, the courts have held that a legal principle can be raised even if not pleaded. It can be raised at any stage. But a factual submission can't be brought in for the first time at the stage of appeal or even at the stage of Section 34. A factual submission not raised before the arbitral tribunal cannot be raised for the first time in a Section 37 appeal. But a legal principle, even if not highlighted earlier, may be taken at a Section 37 appeal stage. I hope that answers it in both the light of the facts of this particular Reliance case, as well as a general principle where this scenario is attractive.
So we have another question in chat box from Rimchim that says, do you think that business and even the courts in India rely too much on retired judges? Does this in a way narrow the entry of other young lawyers and others as arbitrators, and arbitration is becoming more like a court proceeding?
The earlier practice was more to rely on retired judges. There has been a shift in the recent times to appoint arbitrators who have not been judges in the past. For example, some experts in the field of an infrastructure contract, for example, construction of roads, you'll see one of the arbitrator being uh, an expert in the field of engineering or civil engineering works. You'll also see that there has been a shift from uh, from court appointed arbitrators to institutional arbitrations, where the base of the panel arbitrators goes beyond retired judges and includes senior chartered accountants, senior officers who are expert in the field of engineering, who are experts in the field of scientific areas as being panel arbitrators. So there is a shift which is happening. The reason to rely on retired judges is you see there is a sound reason for it. The sound reason is that the retired judges, because of their vast experience, have the know-how of all the legal principles, which a person or a young arbitrator who has not fully practiced in the area of law may not know. So I in fact, I believe that there should be regular training sessions for arbitrators so that even arbitrators who don't have a law background can benefit from it and can at least get the understanding of first principles and the basic legal uh, principles.
Hello, Laltaksh. I'm really
Hi.
thankful for this session. It was really a great opportunity to listen to you again. Uh, we had Laltaksh in our Amity University's another online webinar last year, and this time again, you nicely presented the practical aspects of the judgment. We were really insightful. It was really insightful to listen to this whole discussion. And again, thank you for answering all the questions. Um, Now over to all the
Thanks,
anchors here.
thanks, Shobita. Thank you, Shobita, for this was coordinated very seamlessly. Uh, I had a great time. Before I end, I was, I had the opportunity to join in the last 10 minutes of the previous session. And I remember somebody had asked the question of distinguishing features between plaint and a statement of claim. So I would just like to add one point over there. One of the significant distinctions between plaint and statement of claim is the aspect of course, my friend had rightly mentioned the principles of CPC are not strictly applicable, and you'll find a distinction in Order 6 of the CPC, which says what are the essential ingredients of plaint. But one of the significant distinction is the court fee. On a plaint, the lawyers have to affix court fee depending on the relief sought in the plaint. In statement of claim, there is no court fee as such. The cost is associated with the fee of the arbitral tribunal, but there is no court fee associated with the statement of claim. Over to the anchors. Thanks.
Thank you, sir, for the brilliant session full of valuable insights. We now move forward with Advocate Costam Som. Costam Som, sir, is a senior associate at Samvad Partners, where he previously held the title of associate. Prior to this, sir worked as an associate at Chloros Law Associate. Sir holds a BA LLB degree from Symbiosis Law School, Pune. He completed AISSCE in 2011 from Hemshila Model School and ICSC in 2009 from St. Xavier School, Durgapur. Sir, kindly join us.
Thank you. Thank you for the warm introduction. I'm grateful for this opportunity. I thank the ADR committee at Amity Jaipur for this. And before I proceed to project my slides, I would encourage all of you to make this as interactive as possible. I encourage you all to raise questions whenever you feel like so that I can answer it on the go. If that or otherwise, like you have done for the previous sessions, you can post it in the chat box also, which I will address at the end. I hope I am audible and visible and my slides are visible.
Yes, sir, you are visible and slides are also visible.
Thank you. Thank you. So I would be dealing with enforcement of arbitration awards. Now, this is a topic which none of us, I mean, I would love to know if any of the practitioners joining the session would have been aware about what would be the challenges in enforcement of a particular award. Now, under the new act, the arbitration proceedings, given it's a domestic arbitration, are supposed to end within a ballpark period of 2 years. Now, the prior to the proceedings, there are other steps which have to be taken. Those take roughly at the lowest to about 6 months. Now, after the 2.5 year period of going ahead with the arbitration proceedings, and then finally a successful party getting an award, then comes the challenging phase of getting the award enforced. Now, what would getting an award enforced mean? So, whatever has been decided by the arbitral tribunal, one party wins on, let's assume, some of his claims. The this particular party, who is the award holder, has something to claim against the judgment debtors, who can be one or many. Now, now the judgment debtor does not want to pay or comply with the arbitral award. Now, in such a situation, what are the challenges which are being faced? Now, suppose this is an entity, the award is in favor of an entity who runs a sole proprietorship concern. His bread and butter and everything, his whole livelihood is dependent on his proprietorship concern and the earnings he gets from it. Now, in such an event, if the fruits of the award are not given to that person, then there is a chance that his sustainability of his business, his sustainability to earn his livelihood, to carry out his day-to-day expenditure, all of that comes in. I mean, it's a gloomy state of affairs which can result if the award is not enforced in time. So this is something which we have been grappling with after I came into practice, that even after the, like I said, the 2.5 period of domestic arbitration, you get an award in your favor, and then there is a challenge to make the other party pay. You issue notices, they don't respond, they deny that there is certain objections to the arbitral award which has been passed. They say that I am going to file a section 34, and the earlier speaker has shown how, to what extent the section 34 proceedings can be dragged on. And then after that, you go and file for an execution proceedings, then the notice is to be issued, then the other party may not come forth. Then there are several other challenges. So I would be dealing with what all is the governing law uh, which can be, I mean, which governs the entire system of enforcement of awards, which is equally crucial. I mean, it's actually the fruits of the entire system of arbitration potentially hinges on how good the enforcement infrastructure in a particular country is. So if the infrastructure for enforcement, including the legal infrastructure, being the number of courts, the dockets of these courts, the availability of judges to take up matters in time, the infrastructure to issue notices, to carry out inquiries, to check regarding, to inspect rather, what are the assets of the judgment debtor. So all of these play a huge role in how a particular business would be keen on doing business with Indian entities. So this is my first slide. So this is just an overview of what I would be covering. I would be introducing the 1996 Arbitration Act. Then I would cover enforcement under Part 2 of the Arbitration Act. Then I would be moving ahead with the framework of domestic award. Why I'm covering Part 2 first and Part 1 second, that also I'll tell you, and there is a brief justification for that. And then I would cover jurisdiction, then the applicable limitation for enforcement proceedings, then the interim measures under Section 9 of the Act, to what extent that could be utilized and that could be addressed, pressed upon to ensure that the enforcement and the award basically is not rendered a paper award merely. Then the mechanism for enforcement under the CPC, and I would be discussing, and I want the last bit of the session to be more interactive, where I address your questions where on the challenges which are faced. So moving on, I would go to the next slide. So basically, what is the Arbitration Act? All of you are aware what is the Arbitration Act. The arbitration in India was previously governed by the Arbitration Act of 1940, that was replaced by the UN Model Law. The Model Law came in 1995, if I'm not wrong. And then subsequently, all over the world, the countries decided to revamp their arbitration legislations to somewhat conform with the standards of the Model Law. England had its Arbitration Act in 1996. We also had our Arbitration and Conciliation Act in 1996. Now, Part 1 of the Arbitration Act clearly primarily only limited to domestic arbitrations, or specifically arbitrations which are seated in India. And the term which has been used in the Act is the place of arbitration is in India. For that, Part 1 would apply. Part 2 applies to the limited aspect of enforcement of certain foreign awards. Now, Part 2 is again classified into two parts. First part relates to enforcement under the New York Convention. The second part deals with the older convention which was in existence prior to the New York Convention, which is the Geneva Convention of 1924. Geneva Convention being of 1924 vintage, which was under the League of Nations, is mostly redundant. That is my view. And most of the arbitration awards which are currently being examined or being considered or are of relevance fall under the New York Convention awards. There are 172 countries who are part of the New York Convention, and the number for the Geneva Convention parties are 28. So you can understand why I say that the provisions relating to the Geneva Convention are more or less redundant. And so this is the background. So what happens is that enforcement is not provided for in detail in the Arbitration Act. The Arbitration Act is limited to pointing out that, see, this is where the arbitration proceedings conclude. There is a procedure to challenge the arbitration award which you get if it is in India. Once that procedure is carried out, there is an appeal, and then the arbitration proceedings, so far as the Act is concerned, gets terminated. Then there is the stage of enforcement of the award. So the nitty-gritties of enforcement is governed by the CPC. So I would come to each of the provisions, and nitty-gritties of the enforcement of the arbitration award under both Part 1 and Part 2 would be governed by CPC. So that is the reason why I am taking up uh, Part 2 first, because once the tests and the requirements under Part 2 are complied with, it ends the ultimate culmination of the proceedings under Part 2 is that the award becomes a decree which can be enforced in courts in India. And similar is the process for under Part 1, which is that once the timeline to challenge the award or to set aside the award under Section 34 gets over, then it becomes enforceable as a decree of a civil code. So this is, like I said, chapter 1 of part 2 deal from sections 44 to 52 deal with the New York Convention. Chapter 2 deals from 53 to 60 relates to the Geneva Convention. Now, section 44 and 53, these are the respective definitions of a foreign award. So foreign award is an arbitral award on differences arising out of a commercial legal relationship. Now the commercial has to be commercial as understood under Indian law. I would just impress upon the definition for a second. I'll just read out the definition. In this chapter, unless the context otherwise requires, foreign award means an award on differences between persons arising out of legal relationships, whether contractual or not, considered as commercial under the law in force in India, made on or after the 11th day of October 1960, which is in pursuance of an agreement in writing for arbitration to which the convention set forth in first schedule applies, which is the New York Convention, and in one such territory as a central government being satisfied that the reciprocal provisions have been made, may by notification in the official gazette declare to be territories to which the said convention applies. So as you can see, these are the conditions: made on or after October 1960 or July 1924, in pursuance of an agreement in writing to which the New York Convention or the Geneva Protocol applies, in a territory notified by the central government as a reciprocating territory. Now, like I mentioned, although there are 172 signatories to the New York Convention, there are only 43 countries who have been notified to be a reciprocating country, meaning awards passed by India in India for arbitration seated in India, international arbitration seated in India, would be enforceable as a decree of a court in 43 countries without it requiring any additional proof. Then section 46 to 45 is that an enforceable foreign award is binding on the persons who are parties to the same. Such persons may rely on the award by way of defense, set off, or otherwise in legal proceedings in India. Now, if you notice, I have underlined who are parties to the same. There is a slight distinction between the regime with respect to domestic and international and foreign awards. While I would want you to recall this requirement, that so basically it provides that a foreign award is limited in its enforceability to whoever are the parties to that particular award. Now, what would be relevant is if such awards are to be enforced in India, whether the doctrine of group of companies would come into play with respect to enforcement. We would come to answering that subsequently. So I want you to recall this provision later. Moving on to the third slide, this deals with sections 47 and 56. This is evidence of a foreign award for enforcement. This also clarifies that court under both the chapters would mean the High Court. So this would be High Court irrespective of whether the concerned High Court has an original civil jurisdiction or not. For the High Courts which do not have a original civil jurisdiction, even for those, it would go before the High Court for enforcement. The parties, so these are the requirements which are specified, which is common for both under New York Convention and under the Geneva Protocol. Original award or duly authenticated copy, original arbitration agreement or a duly certified copy, necessary evidence to prove that the award was a foreign award. If the language of the award is in language other than English, the award shall be accompanied by a translation. So these are basic requirements which have to be followed for the courts to recognize a particular award to be a foreign award. Moving on, the next slide is 48 and 57. 48 is for New York Convention, Geneva Convention, it is 57. These are the grounds under which enforcement may be refused. Now, I would dwell on this particular slide for some time because it is important to understand how would grounds for enforcement be raised for a foreign award. Now, for a particular foreign award which is not seated in India, it is the position of law, I mean, established worldwide, that the country having the seat would have jurisdiction for setting aside. So, going by the analogy of the Indian Act, for a foreign award concerning an Indian party, it would be the part one of that particular foreign territory's legislation, which would govern the setting aside. So, therefore, the remedies with respect to setting aside has to be exhausted in the foreign territory courts and not in India. So if once all of those, it becomes an award becomes final as per the foreign territory courts laws, then it can be enforced in India. Now, once it is enforced in India, there are a few additional grounds which could be raised by a party who wants to resist enforcement. Now, these grounds, which are slightly different from the grounds for setting aside, as have been covered by Laltaksh, the earlier speaker, and you will understand. So these are a broad summary of what are the grounds which are available under 48.1. So under 48.1, enforcement may be refused upon production of proof of the following grounds. Parties to the arbitration agreement were under some incapacity. Now, incapacity is to be judged on the basis of laws governing laws existing in India. Because incapacity, whether the parties were under some incapacity with qua the laws governing the foreign territory, would be decided by the seat court in the setting aside proceedings more appropriately. So for enforcement, there is another test that for an award to be enforceable, there is a requirement, there can be a ground which can be raised with respect to incapacity of a party. The agreement was not valid under the governing law or law of the seat of the arbitration. So this is another ground which can be taken. So arbitration agreement has to be valid with respect to the jurisdiction of the seat of the arbitration, which is the foreign country. The third ground is a party was not given proper notice of the appointment of the arbitrators or the arbitration, or was otherwise unable to present its case. So this is similar to violation of principles of natural justice, which is the duty of the arbitral tribunal to ensure. that sufficient notice is given to the other side. Without sufficient notice, the arbitration should not proceed. If there is if the requirements of adequate notice as per the laws of the seat is satisfied, only then the arbitration should proceed and any subsequent award may be passed. Then is the issue of arbitral tribunal exceeded its jurisdiction. Now, it is understood that the arbitral tribunal derives its jurisdiction from the arbitration agreement. Now, if the arbitration agreement specified certain limitations on the powers of the arbitral tribunal and that has been exceeded, then in that case, the enforcing court can decide whether that award can be enforced in that particular territory. Then the composition of the arbitral tribunal or the arbitral procedure is not in accordance with the agreement of the parties or the law of the seat of the arbitration. So this is another test. Another ground which can be raised is that the composition of the arbitral tribunal did not comply with the laws of the seat. So this is irrespective of whether this is a ground in the setting aside jurisdiction or not. So this is ground which can be independently taken. So in international commercial arbitrations, all these grounds are very important to be taken note of during the arbitration proceedings itself, because the party should be aware of the final outcome, meaning that once an award is obtained and it is not the same jurisdiction which is going to enforce the award, then it also has to meet certain standards of the relevant country which is going to enforce the award against the defaulting party. Then the award has not become binding under the law of the seat of arbitration. So this is similar to the interplay of section 34 and 36, which I'll be coming to. Section 36 says that once the time period for challenging or for setting aside of the award is exhausted, which is 90 days, then an award becomes enforceable. So if that is not complied with for the particular foreign jurisdiction, then that particular award would not be enforceable in India also. Then the award has been set aside or suspended by a court of the seat of the arbitration, which usually happens in the setting aside jurisdiction of the respective seat. Now, all these issues relating to enforcement under 48 of the Act has been dealt with recently. I mean, now it has been quite some time in this judgment of Union of India versus Vedanta Limited. So here it was an arbitration seated in Malaysia where a few important points have been clarified. So it essentially clarifies that a foreign award becomes a decree once the stages of section 47, which is I'll move to the earlier slide, which is on the evidence of the award is satisfied. And once the grounds under section 48(1) are complied with, then are considered, then it becomes enforceable under Indian law, and it becomes essentially a decree which can be enforced. The other important points which has been clarified are that the courts there is a distinction between setting aside jurisdiction, which is with respect given on the respective seat jurisdiction, which in our case is section 34, that it is not the job of the seat court, and the enforcing court cannot sit and appeal over what the seat court has done with respect to its setting aside jurisdiction. Now, this is very important because the parties usually tend to put forth the same grounds which have already been decided and rejected by the seat court at the enforcement stage again, and possibly showing that the seat court has been wrong in deciding that particular ground. So this judgment provides an important clarity that the enforcing court cannot sit in appeal against the decisions of the seat court with respect to setting aside. The second important point is that the court can exercise its discretion to enforce where overall justice was done between the parties. Now, this is again very important because, like I read out all of these grounds, even in a case where one or two grounds are made out, but the judge is of the view that overall justice was done between the parties, then there is a discretion vested on the judge to enforce the award also. Now, of course, there has to be some reason to meet the requirement that overall justice is being done to the parties, and there is no compromise with respect to uh, the essential basic principles which governs Indian law. Like Laltaksh has given one example where no such instance is there where a party is being given more than what has been paid, is award, given an award exceeding what has been paid for without any reasons. So considering that things like that are not done, however, there has been some lapse possibly on giving a notice, on giving a adequate time, and the party has probably made its representation before the setting aside court. In such cases, the court has to consider whether there has been overall justice to the parties concerned in the arbitration. And the guiding principle with respect to how the enforcement courts should decide such issues are have been laid down, and this is that it cannot review the merits of the award, and there has to be a very narrow interpretation of the grounds for refusal of enforcement, which is under 48.1, and there is very limited discretionary power with respect to these grounds. So I'll move on to the next slide. Next is section 49 and 58, which is on enforcement of a foreign award. Once the court is satisfied that a foreign award is enforceable, the award shall be deemed to be the decree of that court. So like I said, as has been clarified in the Vedanta judgment, once the stages under 47 and 48 are overcome by the parties, then it becomes enforceable as a decree of a domestic court. Then section 50 and 59 provides for appealable orders. So these are essentially orders where a particular court, the High Court in this case, refuses enforcement. Then there is an appeal against that, and it can go before either the division bench of the High Court or the Supreme Court. That power is also the power to move the Supreme Court under SLP is not taken away. That is also there. Although there is a restriction on second appeal. So there would be possibly one appeal at the intra-court level with respect to the High Court. And then if the party is still unsatisfied, then it can move the Supreme Court. Then, so this is basically what next is what the party seeking enforcement must confirm with the procedure, that he has to give notice to the other party informing that an application for enforcement has been filed. Once the service of notice is done, the court shall proceed to hear the parties and examine the existence or otherwise of the two conditions as found in section 48.2 and 57.2 of the Act and objections filed under 48.1. If the award is found to be enforceable, then it will be deemed to be a decree of the court under section 49 and 58, like I have mentioned. Now, I would just dwell upon section 48.2 for a moment. 48.2 provides that enforcement of an award may also be refused if the court finds that the subject matter or of the difference is not capable of settlement by arbitration under the law of India, or the enforcement of the award would be contrary to the public policy of India. Now, this is again very important. Like in India, if a particular dispute is decided to be non-arbitrable, then any arbitration award on that aspect of a dispute would not be enforceable in India. And of course, public policy. Public policy is also a ground for restricting enforcement. But regarding the subject matter of arbitration, there could be one example where suppose in some jurisdiction, family law disputes regarding adoption and maintenance could be arbitrable, but such family law disputes are not arbitrable in India. So therefore, if there is an arbitration award which is there in such type of a dispute, then those cannot be enforced in India. I'll move on. So this is the framework of for domestic awards. Now, this is what I was wanting to stress on earlier. So while for foreign awards, the award is only binding on the parties to the particular uh, uh, arbitration proceedings. In India, it is different. It's more broad. And this is the quotation of section 35, which says that subject to this part, an arbitral award shall be final and binding on the parties and the persons claiming under them respectively. So this is very important. Now, particularly in view of trends like litigation financing by third party and third party financing of arbitrations, to what extent that can be done. So this can be cited, Section 35 can be cited as something which enables litigation funding in India. I mean, particularly arbitration funding in India. So arbitration awards could potentially be assigned by the successful party to another third party. And in that case, it would become a person claiming under the party. So in that case also, enforcement could be carried out by the assigned entity. So this is one important distinction with respect to how foreign awards is being treated under Part 2 of the Act and domestic awards are being treated. So uh, there could be a situation where uh, a party a party who has been, suppose a foreign award, the proceeds of a foreign award is being assigned to some other entity who was not a party to the arbitration proceedings, and that particular assigned entity comes to enforce the award in India, then there could be an objection, and it seems to be a valid objection that that particular entity who has been assigned but was not a party to the arbitration proceedings, it would not be binding on that person. So therefore, he cannot claim to enforce that award. Then section 32 is also relevant. It says that the arbitration proceedings shall terminate either with the final award, or if it is terminated as per section 32, which is where the parties don't want to carry out the arbitration, the arbitrator thinks that there are no reasons to suppose the dispute has become infructuous or party does not press their respective claims against the parties, then it can be terminated without ending in an award. Now, this is one instance where this language of section 35 has been relied upon to enforce in enforcement proceedings. Now, this is a very important judgment, which is Charan Properties versus Kasturi and Sons. Now, in this case, what had happened was that an award was obtained, and for enforcement of the award, the parties had approached NCLT. Now, the appeal had come because NCLT and NCLAT refused to enforce the particular award. So that relates to registration of a change in shareholding. So in that case, Supreme Court held that award is binding on also the persons and persons claiming under them. So with respect to that, it has laid down that the expression persons claiming under them in section 35 is a legislative recognition of the doctrine that besides the parties, an arbitral award binds every person whose capacity or position is derived from and is the same as a party to the proceedings. Having derived its capacity from a party and being in the same position as a party to the proceedings, binds a person who claims under it. The issue in every such case is whether the person against whom the arbitral award is sought to be enforced is one who claims under a party to the agreement. So, merely because a particular entity was not a party to the arbitration proceeding, but he has received some unfair benefit which has been held to be illegal by the award, he cannot deny enforcement or execution of the award by saying that I was not a party, I was not heard. So if a particular entity has received some unfair benefit out of some subject matter of an arbitration dispute, and that arbitration dispute has been adjudicated, terminating in an award, that award is also enforceable against that third party. Now, recently, there has been the Constitution Bench judgment of Cox and Kings, which also upheld the principle of group of companies in arbitration law. That is different, that needs some elaboration. I mean, that could be a separate topic in itself. But that decision has affirmed the Charan Properties decision, and there is one portion in the judgment which I wanted to highlight, is that there also it was held that the foundational basis for the provision is commercial efficacy, as it ensures that an arbitral award leads to finality, such that both the parties and all the persons claiming through or under them do not re-agitate the claims. So here the court notices that often what happens is that although suppose in a group of company structure, although it is the parent company who carries out the negotiation, the execution prior to the execution of the contract, who carries out the negotiation with the counterparty, and then finally the arbitration agreement is signed by some subsidiary. So even then, there is some value in impleading the holding company also as a party to the arbitration proceedings, because that is how the current commercial transactions are being operated throughout the world. So that has been recognized by the Supreme Court, and therefore, to that extent, the principle of group of companies have been found to be good law under arbitration. Now, coming to section 36, which is the main provision dealing with filing of the enforcement proceedings. Now, 36(1) provides that the award shall be enforceable as per CPC as if it were a decree of the court when the time for making an application to set aside the award as prescribed under section 34, which is 3 months, has expired. Also relevant with the 3 months period is provision section 33, which relates to any clerical mistakes in the award, which has to be pointed out to the tribunal within 30 days. Now, if that correction if there is an application under section 33 within 30 days, and if there is a subsequent correction in the award, then the period for challenge under section 34 gets extended by 90 days from the date of the corrected award. Also, which is something which we should also note, is the proviso to section 34(3), which provides for a grace period of 30 days beyond 3 months. And the amended section 36 is also important, because what had happened, the position under the unamended section 36 is that, so if within the 3 months period an application has been filed for setting aside, and that particular application has been dismissed, then from the date of the dismissal, the award becomes enforceable. So that was the specification which was given. Now that provision has been removed, because now it says that there is no automatic stay, and so a party has to wait for 3 months from the date of the award, and after that, irrespective of whether any section 34 application has been filed or not, that award becomes enforceable. This has been upheld by the Bombay High Court, which has also been upheld by the Supreme Court in this case, is that under the 2015 Amendment Act, the award becomes enforceable after expiry of 3 months from the date of the award, irrespective of whether a challenge has been filed under Section 34 or not. So a party cannot take benefit of the 30-day period to say that the arbitral award has not become enforceable. Moving on, Section 36(2), which clarifies that mere filing of the Section 34 application will not make the award unenforceable. The court has to grant stay of operation of the arbitral award on a separate application made for that purpose. Now, there is a clear requirement that there has to be an interim application for stay of the award, which has to be passed and which has to be decided, and proper reasons have to be given. And only then can enforcement proceedings be restrained. Moving on to the next slide. This is 36.3. Now, 36.3 is one proviso has been added by a recent amendment of 2021, which has been criticized a lot by the arbitration lawyers. So 36.3 provides that a court granting stay of operation of the award may impose conditions on the stay of operation of the award and has to record its reasons in writing. Now, there is a proviso which says that for stay of awards directing payment of money, the court considering the application shall have due regard to CPC provisions for grant of stay of a money decree, which is fine, which is nothing out of the ordinary. Proviso 2 is a little problematic, which says that a court shall unconditionally stay an award pending disposal of the challenge under Section 34 if a prima facie case is made out that the following were induced or affected by fraud or corruption: the arbitration agreement or the contract which is the basis of the award, and the making of the award. So if there is some fraudulent conduct by either parties, or there is some corruption involved with respect to execution of the arbitration agreement or the governing agreement, then the entire proceedings can be stalled. And there only has to be a prima facie determination of existence of any fraud or corruption. And if that is satisfied, then there is a stay. And there cannot be any conditional stay. So suppose an award asks you to do 10 things. The court may impose in other cases conditions such as you comply with 1, 2, 3, 4. The critical aspects, which are the remaining conditions, can be stayed subject to compliance of the other directions. So that cannot be done in case there is fraud or corruption. Now, what is problematic is that this proviso 2 applies retrospectively, and it appears that it applies to all awards which have been passed since inception of time till date, irrespective of when the proviso came into effect. Now, against this, there is prior, when this provision came into being, there was already the judgment of the Supreme Court in Hindustan Constructions, which decided on the validity of the 2019 amendment, which also provided for retrospectivity with respect to enforcement of awards. So that has been held to be unlawful by the Supreme Court. And after that judgment has come, this is the proviso which has been inserted, which essentially says the same thing. But to what extent this is decided to be valid or invalid, that is still to be seen. This is probably a response to the Union of India being on the losing side in multiple big ticket arbitrations, where there have been instances where gross corruption and other scandalous activities were involved. And considering the huge amounts involved, it was possibly important that such a provision was made into law. Moving on, so this is with respect to jurisdiction. Jurisdiction has now been clarified. So earlier there was a conflict with respect to Section 21E, which defined courts under Part 1, and Section 42 of Part 1 of the Act, on which court would have jurisdiction, whether it is the court of the location where the arbitration proceedings were held, which would have jurisdiction, or is it the subject matter test under CBC, under Section 19. So that has been clarified. Now the position is that enforcement of an award through its execution can be filed anywhere in the country where such decree can be executed. And there is no requirement for obtaining a transfer of the decree from the court, which would have jurisdiction over the arbitral proceedings as required under Section 39 for execution of decree. So briefly, what the position was prior to this was that the court passing the decree would be the execution court. You have to approach that court, and that court then transfers it to the relevant court, which over which suppose the property or the assets of the judgment debtor lies. Then once the transfer is done, then the transferred court takes over the execution proceedings. So that requirement has been removed with respect to arbitration awards by this judgment. Now, this is one set of pointer which, as a practitioner, you should consider, is that award in international commercial arbitration seated in India, where the subject matter is money, the commercial division of a high court where the assets of the opposite party may lie, and with respect to subject matter which is not money, a commercial division of a high court where the subject matter of the dispute lie, or where the opposite party resides or carries on business or personally works for gain. So this is the broad test which is consistent with the position of law and the existing position under CPC. Now, similarly for domestic awards, it need not be the high court. It can be the principal court of the commercial court or the principal civil court. And it can also be the high courts exercising original jurisdiction. Now, with respect to limitation, this is the position. Article 136 of the Limitation Act would govern domestic awards, as in domestic awards, be it international commercial awards or purely domestic awards between domestic parties seated in India. It would be 12 years. For enforcement, the period of time is 12 years. This is the extract of the Limitation Act. So 12 years basically from when the decree comes. And with respect to arbitrations, it would be 12 years plus the 90 days period of Section 34. With respect to foreign awards, the period of limitation is 3 years. This has been clarified by the Vedanta case. Now, however, there is one respite which has been granted in the Vedanta case, which is that the 3-year period is subject to condonation of delay under Section 5 of the Limitation Act, where sufficient cause is shown by the party. So that 3 years may also be extended for due cause. Now, Section 9 also becomes relevant at the post-arbitration stage. So this is the language for Section 9, which applies before or during the arbitral proceedings, or at any time after the making of the arbitral award, but before it is enforced in accordance with Section 36. So essentially, ideally, once the award comes, in the cooling off period of 90 days, till the time you can file a Section 36, you can move an application under Section 9, which may be decided. Now, the test of prima facie case need not be satisfied once there is an order which is to be enforced. The prima facie case then becomes essentially whether the judgment debtor is likely to siphon off its assets, take their assets away from enforcement, or there is some other extraneous factors which are relevant to make the award final and enforceable upon completion. So interim awards, again under section 9, is quite broad. These are the general sort of orders which may be passed. This is actually a extract of the provision. Now there are, I mean, the court has the flexibility under section 9 to, tailor make its directions to suit a particular fact. Now, broadly, it can be for preservation or interim custody or sale of goods, which is the subject matter of the arbitration agreement, securing the amount in dispute in the arbitration. Now, this becomes the entire award dues. Third is the detention or preservation or inspection of any property, which is the subject matter of the dispute. Fourth is interim injunction or appointment of a receiver. And E is the broad provision of any other order which the court can pass, which is convenient. Now, one important clarification which has been done is that even for foreign awards, Section 9 would apply. So now that position has been clarified with the judgment of the Supreme Court in PASL Wind from 2021, where the court has noted that the 2015 amendment has specifically included a proviso in Section 2.2 saying that certain parts included in Section 9 would apply to proceedings under Part 2 of the Arbitration Act, which is for enforcement of foreign awards. Now, moving on to the mechanism of enforcement. Mechanism of enforcement is again dependent on the actual relief which has been awarded in the arbitration award. It can be a money decree where one party has to pay the other party. Then in such situations, it becomes a little easier what would be the type of deductions which may be passed. Section 51 of the CPC lays down what could be the deduction. I'll just read out: by delivery of a property specifically decreed, by attachment or by sale without attachment of the property, by arrest or detention in prison. This is also very important. Now, if a particular party is not complying with the award or is not does not show any intention to comply with the award, then an application can be made by the judgment holder to say that please issue a show cause notice to the judgment debtor, asking him why he should not be put in civil prison. Then by appointing a receiver and in such other manner as the relief granted may require. This is broadly what the powers of the court are. Now, Order 21 of the CPC provides the entire host of governing law, basically, which would apply in case there is a attachment of a property, whether the property is movable or not, immovable or not. Well, if there is a sale which is to be conducted, then how the valuation is to be done, who is to conduct the sale. Entirety of that is covered under Order 21 of the CPC. The easier route for enforcement, and that has been our experience, is by attachment of bank accounts of the judgment debtor. If it is a money decree, then that is what is the most efficient way of enforcing a dispute. Now, of course, if there are multiple bank accounts across different jurisdictions, then there are some constraints in essentially complying with the order. However, if there is and the other challenge is if there is insufficient money in the bank accounts to satisfy the award. So that is also another challenge which is there. In that case, the other option is to go for attachment of other assets of the judgment holder. Now, regarding attachment of assets, there is a written application. There is a mechanism for disclosure of the judgment debtor's assets for attachment of property. Now, once there is an application under Order 21, Rule 41, an application has to be made to the court by the decree holder. The decree holder ask the court to issue directions on the judgment debtor to provide a list of his assets, which would be sufficient for uh, satisfying the award. So that can be done once a disclosure comes before the court. Then it's better to strategize for the further steps. Now, from the disclosure, it can be a case that there is insufficient balance from the properties disclosed to satisfy the award. Now, in such a situation, either there can be an application for civil imprisonment, or there can be an application to attachment of bank accounts or any other assets. Receiver can be appointed. There could be some inspectors who can be appointed. The court officials can go and inspect the properties of the judgment debtor, and all these proceedings would take shape once there is a disclosure by the judgment debtor. So this is a very critical step for a non-complying party to go to. And rest, these are the major provisions which come to a judgment holder's rescue. And this would be the end. Now, challenges, one major challenge, like I had mentioned at the beginning, is the dilatory tactics used by the judgment debtor. In most cases, they refuse to attend the hearings, they refuse service of the notice, they don't attend court proceedings. Even if they attend, they request for frivolous adjournments, they try to bring out any challenge against the award at the enforcement stage. Now, all those things have to be decided and by the court. Now, although there are sufficient law on those aspects that the merits of the dispute of would not be gone into by the enforcement court, but still these are tactics which are often used. Now, to navigate those tactics becomes a challenge for any judgment holder. The second is lack of information about assets. Now, this is also very relevant because if you don't know where the assets of the judgment debtor are, firstly, you don't know what would be the ideal jurisdiction. Second, you don't know, I mean, without the disclosure by the judgment debtor, it becomes an issue to personally find out or engage some expert to create an inventory of asset of the judgment debtor which can satisfy your debts. Now, there is no public repository for most of this information, and essentially there are experts in the industry who provides these kind of services where you essentially look at from publicly available data or otherwise you get a sense of where the assets of a particular judgment holder are located, and then accordingly you proceed against those properties. Now, there is an important judgment of the Supreme Court, and which is very recent. This, in fact, this came out last month. This is Pediammal versus Rajmani. The Supreme Court directed that execution proceedings, and this was with respect to proceedings before the court, were to be disposed within 6 months and without fail. Otherwise, the concerned presiding officer would be answerable to the High Court on its administrative side. Now, this is very important because on one hand, although there is a strict obligation on the lower judiciary to do its job within 6 months, otherwise there would be action on the administrative side. The High Court is not being made part of this scope of these directions. So essentially, the High Court would not be technically be bound to complete it within 6 months, although the district judiciary would be mandatorily bound to dispose the execution proceedings in 6 months. Now, it is quite normal for any practitioner to see that execution proceedings are going on for over 5 years, 6 years, 10 years after a particular decree or an award has been filed. So in such case, whether at all it is feasible or not to conclude the whole execution proceedings in 6 months is something we'll have to look at. Plus, also the challenge would be whether these directions would also apply to the commercial courts or the lower judiciary enforcing arbitration awards. Now, a predominantly number of arbitration awards would be before the district judiciary. Now, whether those awards would also come within the ambit of the directions in this judgment or not, and how it is being interpreted by the lower courts and the high courts respectively, that is something to be seen. But overall, this seems to be a positive step. I would like to answer any questions if there are. That would be the end of my presentation. Thank you.
So there are a few questions in the chat box. Would you like us to read them for you?
Yeah, please.
So, sir, first one is, in your experience, what comment will you make on the statement that arbitration is a speedy and cost-effective way of dispute resolution? How long does it take from the invocation of arbitration to realization of the award?
So, cost effective way, I I mean, once the most cost effective way would be to settle a dispute before it goes to the stages of arbitration. The second best cost effective way would be to have it to conclude the arbitration proceedings without minimum delays. And then the tips from Prakardeep would be very relevant on how to make a particular your pleadings and your case materials very crisp, very easy to digest by the arbitrator, so that the arbitrator decides it within with minimal delays. And there is some onus on the arbitrator also to discipline the parties if there are any laxities in their behavior. So if one party takes more time to complete a particular stage of pleadings, then the arbitrator should issue very stern directions. Now that is how I think which could make the process more speedy. Once it goes to court for enforcement, then you don't have that much control over the proceedings. So it mostly depends on which court is functioning when. There are instances where the judges are not appointed in a particular court for months, and because of that, the cases remain pending. There are no directions. So my outlook would be that it's best if you can rush through the process before the arbitrator itself, because that is the stage over which you have most control. Because once it moves beyond the arbitrator's hand and there is an award, then if you have to go to the courts, then it would take its own time, and over there you would have minimal control. Now, like I mentioned, if there are appointments of judges which are pending for a particular jurisdiction, then there is hardly anything which you can do. You can ask for a transfer, but then again, you don't have any say in whether you have whether the in the transfer jurisdiction the things would work smoothly. So this is my. Is there anything? Can you go through the question again?
Sure, sir.
Yeah.
In your experience, what comment will you make on the statement that arbitration is a speedy and cost effective way of dispute resolution? How long does it take from the invocation of arbitration to realization of the award?
So I address the first part. In my experience, there is an arbitration which we have been working since 2019. So the notice of arbitration was sent in 2019. There was obviously the COVID period also in between. So the final award was passed in 2024. And presently, the execution proceedings are pending. Now, this is still at the stage where the parties have appeared twice and there hasn't been any direction to provide a list of assets of the judgment debtor. So, and I foresee that there would be minimal movement in this to ultimately get resolved in the next couple of years. So there is hardly, and particularly it depends on the particular forum and also the parties. Now, there could be a settlement between the parties which could be reached at the post arbitral award stage also, which should always be encouraged by the lawyers. So, because it cuts short the entire legal costs and everything else which comes along with it. So, otherwise, if you go by the process, then there is actually no estimate which any lawyer can provide. It depends on the facts and circumstances. So, ideally, for the entire process of from initiation of the notice till uh, the enforcement proceedings, it can be at the best case it could be 5 years, at the worst case it could be 10 years or beyond that. So that is my estimate. I would love to hear if there are any other practitioners also in the panel who would have any views on this. Yeah, we can move to the next question.
Sure, sir. The second one says, since serious fraud is generally considered non-arbitrable, and sometimes we only discover elements of fraud well into the arbitration proceedings, how should such situation be handled? Should the arbitration stop, or can the tribunal still proceed on other issues?
See, I don't agree with the statement that fraud is discovered for the first time only during the proceedings. The parties would be well aware if there has been a serious fraud way prior to initiation of the proceedings. So if it is not a serious fraud, then maybe it may be in the process of discovery that something comes up and which helps the other side in clinching that particular legal battle. But for any serious fraud, I do not think there could be any situation where the parties are entirely in the dark about the existence of any serious fraud. Or, for instance, let us just assume that there has been some public corruption involved, where certain public servants were involved in procuring the agreement, procuring a particular contract. These are very lucrative sectors where there are a lot of prevention of corruption cases which are pending against several government servants. So I would say that it is usually not the case where serious fraud is discovered for the first time during arbitration. So the parties are usually aware about any serious fraud. But yes, fraud at the granular level, maybe some disclosure was not made when it was to be made, then that is usually discovered. Now, what should be the case? The law is very clear. If there is a serious fraud, then the arbitration proceeding should stop then and there. The party should approach the court, and the other legal proceedings, be it criminal or civil, should take into effect. So that is my understanding. Arbitration should stop if there is a serious fraud which is discovered. And usually such proceedings are objected on the basis of this ground of serious fraud at the initiation stage itself. So there is usually an application for suit for declaration which is filed, saying that it should be declared that the particular dispute is not arbitrable, or there is a section 8 which is passed. So I think serious fraud is usually taken care of prior to parties uh, reaching before the arbitral tribunal. And once there is serious fraud, then the proceeding should stop. I think the law is very clear on that. Yes. Next one.
So the next one is, how many cases in percentage people are going with arbitration in terms of international issues and local issues?
I really wouldn't have the numbers, but in my estimate, uh, there is a usual tendency now. Percentages I would be the wrong person. So it would be very helpful for someone at the ministry level to give out these figures, as in what are the types of contracts and what are the numbers of contracts which are being executed where arbitration clauses are being provided. So that would fairly give an idea of whether arbitration is the preferred choice or not. Usually for international, the percentage would be way higher. That is my experience, because the parties, if there are international parties involved, then the parties do not, there is a general understanding among the parties that I don't want to deal with a foreign court's law and order situation, and that is why the parties usually prefer a neutral seated arbitration or an international commercial arbitration, where the parties are more confident in the law and order situation and about a particular arbitration award being enforceable, the ultimate award being enforceable. Yes, so for the percentages would definitely be higher for international commercial arbitrations. Is there any other questions?
No, sir.
Or
Thank you, sir, for the engaging session and sharing your practical wisdom. To formally conclude this wonderful 2-day workshop, I now invite our faculty convener, Dr. Shobhitab Srivastava, to present the vote of thanks.
Shobhitab sir, kindly join us.
A very good afternoon to one and all present in the meeting. And this is coincidentally a very a fortunate day to conclude our workshop, this being a Good Friday. And on this day, may the message of Good Friday inspire us to follow the path of humility, love, faith, and amicus resolution of disputes, of which ADR methods, particularly arbitration, is a good method of doing so. So I take this opportunity and great intellectual satisfaction in concluding the session, the final session for the workshop, 2 days workshop on arbitration, the practical aspects of arbitration, and the changing dimensions of the same. I thank all the three speakers who joined us today: Prakhar, Advocate Prakhar, Laltaksh, and Kaustubh Som. All the three speeches, lectures were really insightful on the practical aspects. I always appreciate the knowledge on the practical side, especially in these subjects where they are to be combined with the theoretical understanding. I thank Advocate Kaustubh Som to have joined us and shared his experience of the practical insights of arbitration. You have nicely explained, going by section, the enforcement procedures. And we are really glad that you could take time from this holiday when you had other engagements as well. And I also thank all the participants to be here. You joined in huge numbers on this day of, when you could have rested and enjoyed the day otherwise. So yeah, thank you again, and you all of us you were here from 10 a.m. in the morning. We shall soon share the feedback form on the WhatsApp group, and we hope to see you in our further and other programs and events as well. So this was done through Arbitration Area Committee, Pro Bono Club, and Asian Forum for International Academic Interaction. We shall come soon with other events also. Please keep the group joined, and we shall issue the certificate by end of this month. Thank you again for joining us. Thank you, Kaustuv, and thank you all the other participants. Thank you again.
thank you. Bye.
And with that, we conclude this insightful journey. Thank you all for your active participation. We hope this workshop will inspire many of you to explore ADR mechanism further. Wishing you all a wonderful day ahead.